One factor yesterday I missed out. That decision that you were relying upon. Can you ask your junior to just give the citation?
Which one, Miller?
Raj Kishore, just the citation only.
But there is one item number 5.
Huh.
Actually, my lord, there was a review petition. It was allowed on 15/9. That is how it has come. Well, I have some difficulty today, either tomorrow or Tuesday, my lord. Tuesday, my lord.
Tuesday.
Yes.
This is that 11(4)(c). 11(4)(c) says next available
Next
vacancy.
available.
So if it is the next available vacancy, then
Now, whether Lordship is aware of or not, I do not know. Recently, a similar matter was of the view that this. Now, it is true also, because normally if you look at the central rules, where if you are a degree holder, then your qualifying service becomes 5 years. And for diploma, it is, and that is how it is normally done.
the problem here was because I had appeared in such matters, I had examined. When these rules were made, there was a scarcity of degree holder engineers here in the service. So this was a bonus given so that people go and do that course. This
That
was
is not the position now.
now you cannot. Now it is archaic.
And that is how, my lord,
now it is modern law according to you.
Additional Advocate General PN for the department. Perhaps Chief Justice is of the view.
Rightly
done
so.
Proper thing.
Rightly so.
Rightly so.
Rightly so now.
Yes, if you're a degree holder, then your qualifying service will be less.
You are assisted by whom in this matter? Mr. N. Deka, Learned Counsel.
Author is sitting on the other side. That is the difficulty. Sanjay Medi was the lawyer.
Mr. N. Deka, Learned Counsel for Mr. N. Deka, Learned Counsel for the petitioner submits that the present matter be taken up on Tuesday, on 18/11/2025. Prayer is not objected to by the Learned Counsel for the respondents. Also, register to list this matter again on 18/11/2025. That judgment, if you can just.
I'll give it.
Item number 5.
Please, item number matter.
Lordship may fix it on 18th.
Oh, then I take everything on my head on 18th.
Lordship, because
Like
it's an old message.
Asena jaga? 20. On the prayer of Mr. S. Bhuya, Learned Counsel for the. You are appearing for? Department, for the Education Department. Learned Standing Counsel Education Department, who submits that the matter he be accommodated today on account of certain personal inconvenience. Full stop. Prayer is not objected to by Mr. You are not there. You are there.
Subsequent.
S. Borthakur, Learned Counsel for the petitioner. Full stop. Registry to list this matter again on 20/11/2025. It is provided that no further adjournment shall be granted in the matter. That matter wherein I pass the. You will have to be up and going here. Otherwise, Mr. Borthakur is going to blow you. Okay. Yes. 3-0. That we will hear. Affidavit merit we will hear, but what about the 50%? When the matter come up, you just inform me about that. When the matter is taken up.
Can you call the
record to call.
Like to mention item number.
Huh? Rejected.
My senior is out of.
Rejected. Yes. Madam, you will have to be a bit more louder. I'm also getting old. 8. Item number 8.
Advocate AK.
Rejected. Prayer rejected. Prayer is rejected, madam. Be here when the matter is called up. Yes, Mr. Call it. Call it, call it, call it. That cutoff marks. Call it. Four. Mr. Cal, only one thing. There was a change in this steno. I had dictated the matter, then I forgot actually. Only one thing. Whether this petitioner was subsequently promoted to in any, they have been promoted. When? When were you promoted? Okay, you were all promoted to this cadre and then higher cadres also? Huh? Further cadres also? Okay. Just wanted to be clear on that. But the Learning Council for the parties, first of the matter was listed today for placing a query before the Learning Council for the parties. The query on being placed, the Learning Council for the parties have made their respective submissions. Also, accordingly, a registry to list this matter again on 1/12/2021 up to BC9, 1/12/2025 for delivery of orders. 1/12. Anything further to be, any argument, any document? You can just,
I have noted, my lord.
but
And the
Mr.
judgments which were relied, my lord,
No, you don't supply like that. I'll miss out.
yes, I have.
Make a list.
Yes.
Whatever you are adding,
Yes.
just add that. Heard the Learned Council for the parties at length. Also, hearing concluded, a registry to list this matter again on 4/12/2025 for delivery of orders. When you appear, when Mr. Mujumdar appears, it's a learning experience. 8. Yes. Also, Lekha. But Mr. Full a prayer was made on behalf of Mr. A.K. Purkhaisto, Learned Council for the petitioner for an adjournment in the matter. However, considering the nature of the dispute involved in considering the issue involved in the present writ petition, and also the long pendency of the matter, the prayer for adjournment was rejected. Madam, you are appearing for Mr. Purkhaisto, no? But he was appearing? Okay, fine. But Mr. J.K. Goswami, Learned Council for the respondents. Also, all man rukhi dia kumbata ha. So next time I'll be. Yes. We are dismissing it.
Before lordship. A different matter, sir.
Yes, Mr. Shaw.
In this case, petitioner's husband was under suspension for a period of more than almost 11 years. Between juniors have been promoted, my lord.
Very good.
No seal cover was done, my lord. Subsequently, he was promoted, my lord.
Hmm.
Subsequent.
Hmm.
Order dated Annexure 2, with the proceeding against him was dropped.
Hmm.
Annexure 2, my lord,
Hmm.
that is dropped, my lord. Subsequently, my lord, petitioner applied for promotion. He heard that already juniors have been promoted twice. That is why he prayed for. Then, on the basis of his prayer, my lord, Annexure 4, page 18, is that he was promoted
Hmm.
to the deputy ranger. His seniority as deputy ranger is placed between Pradeep Kumar Das and Arun Manta. And I have annexed the promotion orders, first promotion orders of Kumar Das and Arun Manta. That is at page 20, my lord. Their name has been shown is page 21.
Hmm.
That
Hmm.
is from deputy ranger to the deputy ranger. To the first promotion in 2010.
Hmm.
Their name is shown, my lord, in the serial number 5556. Pradeep Kumar
That is
Das.
private respondent numbers.
My lord.
Respondent numbers.
I have not treated them as respondent, my lord.
How will we now pass an order
I'll leave
to
it
their
your lordship,
prejudice?
my lord. Then again, my lord, they were again promoted, my lord.
12/2/2010. Where is Arun Manta?
Arun Manta is, my lord, that is 56, my lord.
56.
Page 21, my lord.
This was promotion as
Deputy ranger.
deputy ranger.
To the deputy ranger. Pune.
And thereafter? Thereafter?
Thereafter, again, lordship may come to page 27. That is the order to the ranger.
Forest ranger.
Arun Manta name is appears serial number 11, my lord.
Hmm. Okay. These are the facts. These are the facts.
Hello?
This is the only fact.
This is the fact, my
Only
lord.
fact.
And they have
Now
admitted.
tell me two things. Today, if we promote you,
My lord, already he died, my lord.
no, that is a different thing
in
altogether.
accident.
So if we have to give you this retrospective effect, we will be affecting at least serial number 11, Arun Manta. He's not a party. 2, after the person has passed away, he is no longer in service. Now, how can I direct for a retrospective promotion? Will he be able to take over charge? He will not be able to take over charge. I think, anything more to say? Help him.
Yes, not in this case, but there's a, in my lords. As Srivastav, 96.
Yeah, it is not there.
Yes, no,
That is the power of Supreme Court.
yes.
That power I don't have. That power I don't have. Amal Satpati is the latest decision wherein the Supreme Court has said after the retirement, same death, you cannot go back with a retrospective thing because you're not in a position to take over the charge of the post from that day. Assume the charge of the post from that day. And if you are conceding to his claim, I have nothing to say.
Perception that the.
I have nothing to say. I have nothing to say.
In the affidavit, they have admitted it, but
Can't help it.
I leave it
Also-
to lordship, my lord. Any relief can be granted to the
Because
petitioner.
I have other two matters on this side.
So you are making the platform decide.
Some other judgments also.
When did he die?
My lord, 2013, my lord. And he died in harness, my lord. My lord, on motor vehicle accident, my lord,
Okay.
23rd 11, 2013.
Also heard Mr. J. Sharma, learned counsel for the petitioner. Also heard Mr. D. Gugoi, learned standing counsel for his department. The present writ petition has been instituted by the petitioner claiming promotional benefits due to her deceased husband with retrospective effect along with the release of the consequential monetary benefits. Full stop. The husband of the petitioner, while working as a forester grade 1, came to be placed under suspension via an order dated 4/6/2001. Also, the suspension of the petitioner was followed by an initiation of departmental proceedings against. Also, they said departmental proceedings came to be closed via an order dated 14/3/2012, exonerating the petitioner from the charges leveled against him. The period of suspension was also directed to be treated as duty for all purposes. So, the petitioner, on being reinstated in his service, having noticed that his juniors were already considered and promoted to the posts of deputy ranger in the year 2010 and a ranger in the year 2012, approached the respondent authorities praying for his promotion with retrospective effect. So, the materials brought on record reveal that the petitioner herein was considered and promoted to the post of deputy ranger via issuance of an order dated 5/8/2013. So, the petitioner found conceding to his prayer, the respondent authorities promoted the petitioner's husband, to the post of deputy
Ranger, my lord.
ranger via issuance of an order dated 5/8/2013. Full stop. On his such promotion, it was directed that his seniority in the cadre of deputy ranger be placed between Pradeep Kumar Das and Arun Chandra Manta. Full stop. The petitioner thereafter approached the authorities for grant of retrospective effect to his promotion to the rank of deputy ranger and also promotion with retrospective effect to the post of ranger. Full stop. However, during the pendency of the said representations, unfortunately, the husband of the petitioner passed away on 23/11/2013 after being a victim of a motor accident. Full stop. With the above grievance, the present petitioner has instituted the present writ petition after present writ petition, praying for reliefs as noticed herein above. I have heard Mr. J. Sharma. I have heard the learned counsel for the parties and also perused the materials available on board. Also, it is an admitted fact that the petitioner herein was that the husband of the petitioner was placed under suspension via an order dated 4/6/2001. The said order of suspension continued to be in operation till the disciplinary authority, on conclusion of the disciplinary proceedings instituted against the petitioner, passed the order dated 14/3/2012, dropping the proceeding instituted against him and thereby exonerating him from the charges so leveled against him. Also, the period of suspension was also found to have been regularized as on duty. The Materials brought on record reveals that the husband of the petitioner had remained in under suspension for a period of around 10 years, 9 months, for a period more than 10 years. However, it is not borne from the records that the husband of the petitioner had approached this court and or the authorities for setting aside or revoking the order of suspension. Appella. During the period when the petitioner was under suspension, the respondent authorities have proceeded to consider the cases of eligible forester grade 1 for promotion to the rank of deputy ranger. First up, on such consideration being made, the respondent authorities, wide order dated 12/2/2010, proceeded to promote the eligible persons so found, the persons found eligible for such promotion to the rank of deputy ranger. Also, amongst the persons promoted was one Orun Chandra Manta, who is projected to be junior to the petitioner herein in the cadre of forester grade 1. Also, thereafter, the incumbents in the rank of deputy ranger were further considered for promotion to the rank of cadre rank forest ranger, and accordingly, on such consideration being made, the respondent authorities, wide order dated 7/3/2012, proceeded to promote the persons found eligible for such promotion to the rank of forest ranger. First up, Orun Chandra Manta, who is projected to be junior to the petitioner, also was promoted as forest ranger by the said order dated 7/3/2012. Also, the petitioner on his on his reinstatement in service also approached the authorities for considering his case for promotion to the rank of deputy ranger with retrospective effect by submitting a representation dated 19/4/2013. Full stop. In pursuance to the said representation, the respondent authorities proceeded to issue an order dated 5/8/2013, promoting the petitioner herein to the rank of deputy ranger. Also, on his such promotion, the seniority of the petitioner was directed to be fixed between Pradeep Kumar Das and Sri Orun Chandra Manta. Full stop. The order dated 5/8/2013 does not reveal that this promotion effected in respect of the petitioner herein was so effected with a retrospective effect. Also, the petitioner's husband, as noticed herein, unfortunately, was a victim of a motor accident and he passed away on 23/11/2013. Full stop. Above background, the petitioner herein has prayed for grant of retrospective effect to the promotion of the petitioner of her husband to the rank of deputy ranger with effect from 12/2/2010 and to the rank of forest ranger with effect from 29/2/2012. Full stop. The husband of the petitioner no longer being in this world, this court is not in a position to direct for grant of retrospective effect to his such promotion. To retrospective effect to his promotion to the cadre of deputy ranger. This court also notices that the petitioner's husband during his lifetime had not presented any challenge to the order dated 5/8/2013, by which he was promoted with prospective effect to the rank of Deputy Ranger. Also, further, the promotion of the further the direction, the further this court in the event passes any direction granting retrospective effect to the rank, retrospective effect to the promotion of the petitioner to the rank of Deputy Ranger, the same would adversely affect the interest of other persons who were so promoted by the order dated 12/2/2010. This court finds that none of the persons promoted by the order dated 12/2/2010, including said Arun Chandra Manta, has been made a party respondent in the present proceedings. Accordingly, this court, in the absence of the persons who would likely be affected by grant of retrospective effect to the promotion of the petitioner's husband to the rank of Deputy Ranger, would not be in a position to pass any affirmative order in favor of the petitioner herein. Full stop. The petitioner husband has claimed for promotion to the rank of Ranger, Forest Ranger. Also, the materials brought on with effect from 29/2/2012. Petitioner has also prayed for promotion of a husband with effect from 29/2/2012 to the rank of Forest Ranger. Also, this court, noticing that the husband of the petitioner is no longer in this world, and during his lifetime he had been not instituted things in this connection, this court at this juncture cannot direct the respondent authorities to promote the petitioner's husband with retrospective effect to the rank of Forest Ranger, inasmuch as such direction cannot be complied with, inasmuch as the husband of the petitioner cannot assume the charge of the post of Forest Ranger. First, in view of the above conclusions drawn by this court, the present writ petition is held to be devoid of any merit, and accordingly the same stands dismissed.
Fine.
Esto sabe ser, at number.
My lord, not to press the petition.
Not to press. Mr. A.K. Purkhais, learned counsel for the petitioner, submits on instructions that the petitioner desires not to press the writ petition any further. So accordingly, he prays that he be permitted to withdraw the present writ petition. First off, prayer is not objected to by Mr. J.K. Goswami, learned.
As instructed by the claimant.
I've said, Mr. J.K. Goswami, learned additional senior government advocate, does not object to the prayer made by Mr. A.K. Purkhais, the learned counsel for the petition. Accordingly, the present writ petition stands dismissed. Why?
S. Today he is attending some.
Yes, madam, what do you have to say? Okay, we'll hear him. What do you have to say?
Short date since it's a long.
No, you argue.
Start the
You
matter.
can start off. We'll hear Mr. Chamari on the net.
The matter relates to term
Madam, your name was?
P. Gupta.
P. Gupta.
Matter relates to termination. Bank employee, Allahabad Bank. On 26/2014, he was serving as senior manager from 8 September 2008 to 29 November 2011.
It was in pursuance to a departmental proceeding
Yes, pursuant to a department
against order dated
order dated in 20/06/2014. Also appeal dated 17/12/2000.
You were removed.
I was removed from service. Maximum penalty. Lordship on 5th March 2013, he was given a show cause
Just a
notice.
moment, just a moment. Appeal order is
Appeal order is dated 17/12/2014.
17/4/12/2014.
17/12/2014.
Okay. You were working as
I was working as a senior manager, Allahabad Bank,
manager. Which branch?
so Guwahati zone.
Okay. What is the charge against you?
There was 132 charges against me of the similar
About
nature.
same nature, loan,
Yes.
bank loan,
Loan,
car loan.
Yes,
Okay.
saying that KYC norms were not. So a show cause notice was
And
served.
madam, there was also an allegation that around 1.8 crores were
Yes, they have recently filed an additional affidavit that approximately 1.8 crore loss was suffered by the bank.
whether this loss was quantified in the inquiry.
Was not. It was a later additional affidavit filed by them, and this was also because the account was NPA. And
All the accounts were in
yes,
130.
not all the accounts. Certain accounts were NPA and certain accounts were paid in full.
And the charge is that they could not locate the guarantor as well as the people.
So they're saying that KYC.
Some evidence is there.
Yes, some little. So first, your lordship will find the show cause notice in page number 212.
So total there is 130.
132 charges. 131 charges.
30.
Charge sheet is in page number 16 of the writ
Page
petition.
32.
Yes.
130. Yes, madam.
After the charge sheet was furnished to them, they had filed a reply. The delinquished employee had filed a reply to the
Where do I
charge
get
sheet.
that?
Page number 72. Had furnished point.
No. This is against the departmental inquiry report. This was finished.
This was filed prior to the departmental inquiry.
Okay. What
Had
is it?
explained points and not being satisfied with this, apply to the show cause charge sheet, a order for the disciplinary inquiry was passed in page number 100. And
Anything material here? Nothing.
yes, Lordship, there are two people, Roman number 1 and 2. One, Shukesh Chandra Sarkar, appointed as Chief Manager, Inquiry Officer, and Sanjay Bishwas as Presiding Officer. I'm pointing these two names. Bank authority saying that handle the disciplinary inquiry. They don't have any prior training or any prior.
Where is that letter?
Lordship will find it in page number 200. Actually, they have not given us those letter. We had gone through the bank records on one of the dates during court proceeding, and we had filed an additional affidavit asking them to give us those letters, bring it on record. However, they have not brought it on record. And in page number 207, they have written why they have not brought it on record.
Just a moment. $200 and
First, page number 200, there is a table where we had asked them to furnish. Lordship got page 200.
okay, fine. Then
Then on page number 207, they have
you have got
responded.
your.
So both of them not being equipped to handle such a disciplinary inquiry, this was not given any importance.
Okay.
Then the second point is, if I may take your lordship to the findings of the inquiry officer in page number 111.
Okay.
Inquiry report. Lordship, in this inquiry report, no evidence has been discussed, mere charges has been written and it's against those charges written proof. How is it proved on what?
Okay, let us see one. Let us check up one. List of allegation. 5 is the inquiry. Evidences. 6 onwards.
Yes. On having PO written brief received on 15/02 signed, now submits its report finding on inquiry proceeding as under. Charges frame number 91 articles, so and so, and then last it's written charges proved. Which evidence were examined that these charges were proved? Nothing is written. Have not discussed any evidences. All 130 has been done. Charges proved. Now, if I may take your lordship to page number 1, last page of the inquiry.
Hmm.
The last paragraph, it's written similarly. Of article on perusal of CO's reply, it appears that he attempts to submit a cock and bull story without going to the points that is the charges framed against.
Madam, how were these documents introduced in the inquiry?
They had a register. They did not, they asked us to come and check the registers, but
No, I'm not on that. In the inquiry proper, how were these documents placed before the inquiry officer?
they tendered like T1, T2, E1, ME, ME2, ME3.
Who tendered it? Who?
Inquiry officer.
Not getting me. Inquiry officer is the judge. Who tendered the documents before him? Presenting officer, witness,
Presenting officer.
witness?
Presenting officer, there was one witness that was cross-examined.
Where is that? Where do I get that? So this one witness, he produced all the documents.
Yes.
There was some witness, that means.
One witness, bank manager, that time who was handling the branch.
He was MW1. Are you sure that he...
However, lordship, I'll have to cross-verify.
You had cross-examined him also?
We had cross-examined.
Where do I get that
There
cross-examination
is
part?
nothing on record.
Oh, where do I get that cross-examination part?
There is only one in page number 116, cross-examination of DW1, that is us. Only that is mentioned. Otherwise, there is not a that was examined. If it was cross-examined, nothing is mentioned, even in the inquiry report or the disciplinary authority final order. Examination of the delinquent employees.
Okay. Anything more?
And Lordship, after
What is the prejudice cost to you in the inquiry?
Lordship, when the inquiry report was furnished to us, we had written a reply to to the inquiry report. Lordship will find in page number 63. Written specific remarks were made, like certain accounts are already paid in full. Certain accounts were not sanctioned by us. Like in total of 86 accounts where we had explained via this letter that out of 130, 7 accounts were not sanctioned by us. 54 accounts are paying regularly. 22 accounts are standard accounts. And 3 accounts have already been.
So give me a breakup. 80.
86 accounts allegations were explained in this letter. 7 accounts.
Out of 86.
Yes.
Ah.
7 accounts not sanctioned by the manager, delinquent.
Then
4 accounts were paying regular.
so it was not NPA. Yes.
Accounts were standard accounts,
What do you mean by standard accounts?
not NPA. They were paid.
So what is the difference between 54 and 22?
For regularly paying, and 22 sometimes they default on payment, but it cannot be declared as NPA. And 3 accounts have already paid it.
Loan
Here.
completely paid.
Yes. And if I may read point number 1 of page number 6. During the process of inquiry, we were surprised to note that all the questions that PO placed before were prepared by EO himself. This is not only manifested his biasness, but also exhibit blunder tampering of ethics and natural justice. No independence of
Okay.
inquiry officer.
So this is your case.
And later on, when order was passed by the disciplinary court of inquiry officer was accepted in toto. Have not discussed anything.
If he is not going against that, if he is not, if he is accepting the conclusions, why should he write a detailed order?
Has to be a standing order. If a bank employee of a managerial level, inquiry officer and precise saying that they are not equipped, not handling that that matter seriously, or not while passing the order, the officer who himself.
All said and done, madam. You are a bank employee. The conduct of yours is much higher than the conduct expected from the others. Because you are in a position of confidence. The law is, if you lose the confidence, no further, these small things with this court should not go into. So please prepare your matter in that line also. If I hold that there was a loss of confidence, nothing more is required. Please prepare. And we'll have it on 20th. 20th, no? 20th. On that day, please bring on record the inquiry file. Judge Ms. P. Gupta, learned counsel for the petitioner at some length. So, her submission, however, remains inconclusive. So, on the next date of listing, the learned counsel for the respondent bank shall place before this court the records of the inquiry in original.
Obliged.
History to list this matter again on 11/20/25 for further hearing.
But this is a petition filed by the petitioner. He hasn't died, my lords. His wife has been brought in. The petition now. We are challenging in, my lords, penalty, my lords. Penalty given by CRPF, my lords. Charges were, my lords, that I was absent.
Where is the report?
But my lord will find that page 29, annexure 3.
29.
There are two charges, my lords.
That we got it. 3 charges basically. And where is the report of either the inquiry officer or of the? How did they prove these charges against you?
They just went on to harp that I was on some previous occasion also I was absent. Not very, I will kindly see page 31. They prove they took statements of few witnesses. Inquiry officer says, then then they also harp on page 31.171 that I have admitted. Whereas, my lords will kindly page number 30, my lords, the days, total days.
You're not coming to the point. Come to the point. What is the error?
Error is, my lords, the person was suffering from mild cerebral atrophy, which is admitted because they have done a test, which is admitted. That was not considered.
That is what I want. Yes. Now his absence is justified by your own examination of him when your composite. Then how can this charge of unauthorized absence stand? I'm not on that. Where is the consideration of the report? When he was brought, when he came to join, you sent him to the composite hospital. Once you sent him there, there was a report given, which matches with the plea taken by him. And this plea was substantiated. His absence was justified. Now, where is in your order of the disciplinary authority, where has this factor been considered?
It remains, my lord.
So that if you don't consider that, the thing goes.
This, my lord.
We see unauthorized absence is, what do you mean by unauthorized absence? Unjustifiable absence. Now, if the absence is justified, how do you punish him for unauthorized absence? Where are the decisions?
Absence has to be willful, my lords.
They are not sufficient. He has got sufficient time.
If he is having this ailment, how can he?
He did not.
That we will condone, because his family had brought him, but you sent him away from the gate itself.
The night.
Be that as it may,
Of course, my lord.
they might be traveling from a long distance. That much compassion you must have. Okay, let us see the charges now.
Yes, 70.
Okay. Now this article of charge number 3 by itself cannot be a charge, can it be? This article number 3 is already punished. This will only add boosting power to 1 and 2. If 1 and 2 is proved, 3 will take him.
Yeah.
Right? Now you show me how you proved 1 and 2.
Will come to page 27.
Huh?
20.
20?
27. Yes, 29.
How old was he then?
Lords, I have to.
You have completed 18 years.
9/2015.
Filing indicates, my lords, is 43 on filing of this petition.
Huh?
The date of filing this petition is 43.
43. So he's around about 43. So say he is 53. With this condition, he cannot come back to service. When did he join the service?
'97. Era 1.
You're getting pension?
Pension is there.
What is the error then? Compulsory retirement. Compulsory retirement.
No, my lord, compulsory time will come when I have done something major. The charge of dissertation was not there. I have not.
You have
deserted.
already been declared as deserter.
No, that has been taken back, my lord. Lordship will find.
Once,
I have-
where do I find that?
I have, my lord, para 6, my pleadings, my lord, page 4.
Forget your pleading. Show me from the document.
Nowhere, my lord, it mentions that I am a deserter.
You were a deserter. Come to page.
And my lord, if I
Come to page 30. Para 2.
it doesn't say so, my lord. Impliedly,
No,
there
you
is a
were,
meaning.
you were, yeah.
There is a meaning. We can.
No,
have
you
information.
were declared you were declared as a
No, my lord.
deserter in the court of inquiry. Is
But
there?
that should be backed by a charge, my lord, because the penal offences and penalties which are prescribed, my lord, deserter, there's a specific word is there, which comes within the domain of these major punishments. And my lord, the judgment which I placed, that absence must be willful.
No, why the information was not given then? Information was not given.
Lord, the malady, the sickness you are suffering from, it's shrinkage of brain cells. my
I know
lord.
that, but why your family members had not reported?
Family had come, my lord,
That is after a few years.
they came to know because, my lord, he was suffering. He had lapse of memory, that relapse. He had some mental issues. My lord, the purpose of these rules is to discipline someone. But they are trying, what they have done is trying to, my lord, impose something. And it's I had only 2 years left for confirmation, that another 2 years for full pension, my lords. The issue, my lords, I was caught by the civil police because of their warrant and produced before them. I didn't have the opportunity to bring the documents also, medical documents also.
In the inquiry, you had not produced any medical document.
My lord, it itself, it was there, my lords. That page 15, it is their own record. Page 15, my lord, it says ADS and hypothyroidism and mild cerebral atrophy of brain. calculate also, my lord, he total in all 3 years, my lord, it's only 49 days.
Where is the judgments you want to rely upon?
Lordship, I had given. My lords, absence has to be willful, my lords.
Who has signed the affidavit here? Who has signed the affidavit in the writ petition?
Petitioner himself at that time, my lords.
How could he sign if he is not mentally well?
No, my lords. The sickness, my lords, this sickness says he's not totally lunatic. He on the verge of, my lord. It's a
But you say
progressive
that
thing, my
he
lord.
is not in a position to even inform the authorities.
No, my lords, he was under the care of the family.
No, I got it. He was not in a position to even inform the authorities. And how do we accept this oath of his to the statements made?
Oh, my lords, informing his authorities
Both
because he
have
was
to
far
be,
away.
both have to be.
Yes, I understand. It has to, it has to be approached from both sides. I have to justify my position from both the sides. My lord, this fellow was in his home care. My lord, I have pleaded.
So he was sane enough
Then-
to understand things.
He didn't know, my lord, this will result into this. Since he had a,
He should not know.
my lord, the very fact,
That is
my lord, the
ingrained.
very fact that the family had
Then
accompanied
we
him.
will not accept the statement on oath here. Because how can we believe that what he is saying, he knows about it?
But he knows because there's a statement my lord, that sickness relapses, my lord. Sometimes it comes, sometimes it relapses.
Relax. So when it goes, why did he not inform?
My lord, the very fact,
Where is your documents to show that you were suffering from this problem from 2014 and you were under treatment?
but the very fact that family had
Okay,
to
fact
accompany, my lord,
will come,
a
fact
member of
will-
a force.
Oh, we'll come to fact,
lord.
but show me the documents you have, which will reveal that you were suffering from this problem from 2014.
But there are no documents there.
Then-
But a,
Then,
from the, my
then
lord,
how do I satisfy myself that
my lord,
he was
para 5, page 4.
of your writ petition?
This course, this is some old mathematics. I was not the counsel. Sir.
Okay. Okay, where do I get support for para 5?
There's no documents that I have to admit. My lord. That I have to admit. My issue is this, my lord. I am being charged with a penalty for an offense, willful. That falls under.
That is what I'm telling you.
Yes, my lord. That falls
Show
under
me
the-
something that you were not in a position to.
My lord, there.
Then how did you participate in where is your plea that my very participation in the inquiry proceeding is non-est? Because if your brain had wasted away, what was the
No, no.
point in?
While cerebral atrophy is not something which comes on a sudden attack, sudden, my lord. It springs, it gradually degenerates. into
But your
Alzheimer's.
statement is that your brain has wasted away.
My lord, that is written, my lord, but the
No, written means what? That is
wasted away,
the,
my lord, it gradually shrinks, which goes to dementia and Alzheimer's.
fine, I understand. And the petitioner's brain of the petitioner had wasted away. So if they wasted away para 6, last line, then how did you participate in the inquiry? How did you respond? How did you swear the affidavit here?
I responded, I just pleaded guilty.
He is alive.
No, my lord, he has.
Oh, he has passed away. Family is before this court. He had instituted these proceedings.
Yes, my lord.
Subsequently, he was substituted. So if his brain is wasted away, let us see the doctor's certificate. Mild cerebral atrophy, mild.
Yes.
But if it is in 2015 mild, it could not have progressed in 2014. It could not have progressed in 2014.
I can assume, my lord, that this has caught him in way back behind 2014. It was
Okay.
progressing.
Okay.
By that date, it was
Okay.
it was
But show me something that because of this, he was not in a position to. Because you were under treatment maybe when you were in your home. Or your family was sitting around you and taking care of you.
then annexure 1, page 14.
I'm on that.
14 and 15.
But that
also.
is on 13/10/3/2015. Fine. But where is the material to show that you were not in a position to avoid alcohol intake? Condition on discharge better. Mr. Gogoi, this will not do.
I have no way out, but because there's some old case, old pleadings, I don't have access to these clients also.
We'll take it up on Monday.
Monday.
You prepare.
I'll do.
Not satisfied.
My lord.
On the prayer of Mr. D. Gogoi, learned counsel for the petitioner. Registry to list this matter again on Monday. You have the records with you? It's coming from, where was the inquiry held? Huh? Get the records. Tuesday, ko idea.
Tuesday.
Get the records.
Okay.
Mr. M.R. Adhikari, learned CGC, shall produce the inquiry records in original, full stop, on the next date of listing.
My lord. Obliged.
Your name, madam?
Pradhani.
Huh? A.S. Pradhani. Heard Miss A.S. Pradhani, learned counsel, appearing on behalf of Mr. H.R. Chaudhary, learned counsel for DP. Also heard, who is appearing for the government? Mr. Roy, you are appearing? Also heard Mr. S.S. Roy, learned counsel, appearing for the state respondents. What happened to Mr. Chaudhary? It is submitted by the learned counsel, submitted by Ms. Pradhani, that the arguing counsel, Mr. H.R. Chaudhary, had to leave Guwahati on account of certain personal inconvenience. Also, she submits that the matter be taken up tomorrow, Monday. Matter be taken up on Monday. Monday. Also, register to list this matter, Duta matter, 14/15 on Wednesday. On Wednesday, 19 for further hearing. Same. Have you got the records? Records. Oh, this is not one, that one. Huh. You filed your affidavit in reply. Why?
The basis of the
Huh? Basis of the material. Okay. Oh, that disclosure of names. Yes, we required madam to produce the records. Why? This is the case. Yes, that Caesar list. That is what. How did you establish this charge against the lady? How did you establish this charge against this lady that she was disclosing information?
Is stated in this.
Where? In a statements before the police, 161. In the inquiry. Mr. Sharma, you prepare your brief, we will take it up after some time. Mr. Pukon, that's the only case you have?
Lord,
That you say that this was forcefully done. Nothing was there. You show me that. Then we'll ask him.
Okay.
We'll take it up at after we go through the list. Complete the list, we'll take it up. Be here. Who is the learned counsel?
Art Devi and I'm for
Madam, have you, the only reason why you have not been granted this MSCP is because you had one adverse ACR, right? It was good. Have you filed an appeal? Have you filed a representation for upgradation of that ACR? Who is the counsel leading you? Where is he?
he's unwell.
As prayed for by the learned counsel for the parties, a registry to list this matter for admission hearing in the month of February 2025. 26. Huh?
I'm being, my lord.
Lordship.
Why? You have already filed. No, no, in Navajyoti Kurmi, no, in Dulal Hussain, I find an affidavit is there. Other cases also something.
It's already
Is
recorded by this Honorable Court's order, my lord. The pleadings are complete.
Complete.
Long back, long back.
last order says pleadings are complete. Wait, give me a reason. I'll pass over the matter, but with a compensation. 3 matters I have read yesterday night. Is all. So a compensation is called for. If there was any problem of any party, they could have submitted a memo. Next time, I'm not going to do that. Next time, it will be adjourned, it will be with a cost. Not for the asking. Both parties. Let Mr. Chaudhary come, we'll see.
Yes.
When Mr. Chaudhary is here, please inform the court master. Oh, yes, Mr. Chaudhary. Yes, why the 50% is not paid? What is the reason? Other than lack of funds. Forget it. I'm not interested. I'm interested with my order. There is an order of a coordinate bench that your undertaking is recorded, that 50% of the remaining amount will be paid by the next month. No, 2 parts. And submits that they will be able to pay the 50% of the remaining amount by the next month.
and here assured also, Lordship.
Okay. What is your right, Mr. Gogoi?
Lordship,
For the direction.
What is the right of the petitioner to claim money from the, you are an employee of some cooperative society.
Some state cooperative union, your lordship.
That union is will a writ maintainable?
Lordship, here in this. case,
Where, how is a writ maintainable here, Mr. Gugoi? It is a private affair between you and your employer.
The
Government has got nothing to do here.
Lordship, fund is
Fund is not
by the
allocated.
Register of
Some
Property.
grants are given.
Yes, that
Grants
have
are
been
given.
That is my own money, always hard money.
For which money?
This GPF. and
Okay, go and file a suit. Get your money with interest.
No, my.
Why should we
submission is that-
be entertaining this petition here? Why should we entertain this petition here, Mr. Gugoi? This why this good.
A fund has been allocated by the government to the to the state
That
cooperative.
is it.
That is the first point.
Oh, the fund from the government has come to the society. Now the society and dispute is between society and Mr. Gugoi. How can a writ be there? It's between you and the society. Go.
If
You do whatever you want. How can a writ be maintainable?
the last occasion, this honorable court has directed the chief executive officer what is the affairs of this case. And he has personally been appeared before this honorable court and undertake that he will refund the,
Satisfy me.
that
That satisfy me that this writ is maintainable.
my humble submission is that we have given our annexer that there is an employee between.
Mr. I got everything. You're not an employee of the government of Assam, are you? You're an employee of the union. The money has already been paid to the union. Union is not disbursing it to you. It's a dispute between you and the union, not the government.
That is what
Not maintainable.
lordship, as per the bylaw of the cooperative state cooperative union, your lordship. This
The writ, it's provided there that you are a government employee.
no, lordship.
Then?
The society's function have been guided by the register of cooperative societies.
Okay, go before the Register of Cooperative Society. If there is, go liquidate this union. Go and liquidate this union. Get the money, assets they have, get it liquidated.
Lordship,
You
this
take
is a-
your money. You want your money. This is not the way. You go file an application for liquidation.
lordship,
The register will liquidate, will then pay you the money.
if lordship permit me us to go for the direction, I have nothing to
No,
say back. But
why go? Okay,
my,
I'll dismiss it, holding that it is not maintainable.
no, lordship, my humble submission.
No, you want a direction, I'm giving you a
No,
direction.
no, my humble.
Then you sit down there now.
I beg to apologize.
Yes. You file an affidavit, don't file an affidavit. First, what about this order? Your undertaking. To release to whom? You have received money. No, after this order, how much amount has been paid? No, after this order passed by this court on 28/8/2025. You have your instructions, 28/8/2025, how much amount has been passed? That order you comply, we are dismissing this writ petition thereafter. Because this writ petition is not maintained, but there is an order of this court. I cannot let it go. It has to be complied with. Once it is complied, then the onus is on Mr. Gugoi. When? Today? Tomorrow? Day after tomorrow, then you will have to come to my chamber.
Your Lordship, Monday.
Tuesday, Wednesday. On the prayer of Mr. J.K. Goswami, learned counsel for the petitioner. Registered to for respondent. Respondent number 2 and 3. Registered to list this matter again on Wednesday. Mr. B.N. Gogoi, learned counsel for the respondent. Mr. Gogoi is, Mr. Goswami further submits that the present writ petition would not be maintainable. The said issue is kept open to be considered on the next date of listing after Mr. Goswami satisfies this court as to the manner in which the undertaking given before this court and recorded in the order dated 28/8/2025 was complied with by the respondent number 2 and 3. I'm sorry, you had the order with you. You did not. I can't go. Mr. Gogoi, prepare that also.
I'm deeply obliged, sir.
Once we are doing something for you, why this exuberance? Remain cool. Remain cool.
Big to apologize.
We need not apologize.
I beg to apologize. I've been absent and for me, Lordship has been taken so much burden. So it is my humble duty to
He
assist.
briefed before me. It's my duty. Do the needful. And we have done the needful. Nothing, neither you nor he, nothing is for me. Okay, fine. Yeah.
Led by Mr. Chu.
We have already had a big list now. On the prayer of the learned counsel for the petitioner.
My lord, maybe on Tuesday then, my lord.
Tuesday, no, Thursday. No, not next week. The week next. 25. Registered to list this matter again on 25/11/2025. Your that two judgments would be a hindrance.
We have also one judgment of the apex court, my lord,
Hmm.
the same issue. Well, that I place,
Give me the citation.
my lord.
What is the citation?
This order is not applicable in this presentation also.
Huh? Let it have it on 20 Korea. What is your citation? Give me the citation name.
Team today, my lord, so that is a.
Print today, no problem. There will be a number there.
Just. Just go ahead.
On 20th.
Right, please, your lordship.
Yes. Mr. Sir. Yes.
Therefore, I am before your lord.
Not considered.
Not considered.
Okay.
Considered but rejected.
Rejected. What is the error in that rejection?
My lord.
Page 77.
Yes, my lord. Page 77. The family of the deceased receives a monthly family pension of rupees is to be sufficient to conservation. Otherwise, also a casual employee gets a lump sum monthly. Also found that after the death of late so and so, the family had received a sum of rupees 30. Also generate a substantial monthly income, hence having regard to of monthly pension and regular income, which can be generated from substantial terminal aggregate amount, it appears that there is sufficient adequate financial resources of the dependents. Hence, the case does not.
Why is this bad?
My lord, this annexure does not reveal how many postal packet.
You forget that. Why is this paragraph bad?
My lord, somebody may have got more amount than others.
No. Why is this paragraph bad? Why is there any factual error in this paragraph?
This may not be solved my lord criteria.
First, let us get out of this. Let us get out of this. Take me out of this.
Yes, my lord, this is
How many members do you have?
for 5, my lord.
Where do I get it?
My lord, from paragraph 3.
Okay, sisters, how old are they?
I have to take.
They have not disclosed.
No, no,
Okay. Anything more? Anything more?
my lord. At page
Page?
79.
Hmm. Hmm.
This is the scheme
Hmm.
for compassionate appointment.
What is the date of death?
2014.
Date.
12/5/20, 2014. My lord, this is the scheme at page 80. Clause 9, subclause 2.
Clause 9, subclause 2.
5% of the vacancies
Oh,
in
very good.
class 3 and 4
Very good. Very good.
post occurring in a year.
Wife's name is Seal.
Where is your head office? Polton Bazaar. File a FIR before the Polton Bazaar. Yes.
5% vacancies in class 4, 3.
File an FIR. It was a fit case for filing an FIR. Yes.
5%.
Mr. Sahu,
My lord,
you were in desperate need of a job when your father died. He died in 2014. Before this, any writ petition filed before this court? Why it took you 10 years to come before this court?
they did not consider.
Because that means you were sustaining for 10 years. For 10 years you were sustaining. Is it a right of yours? Any right? Compassionate appointment, is it a right? Okay. Anything more?
My lord, where is that?
I have seen it. Anything more?
The 5% of vacancies in class 3 and class 4.
Why this 10 years? Where is your explanation with regard to
No,
10 years?
Actually, my lord, kindly see at 2010, they have asked me. That is at page, Annexure 7, page 31, my lord.
Okay.
On 7/8/2020,
Okay.
they have asked me to submit documents, my lord.
Okay. Thank you. Heard Mr. S. Sahu, learned counsel for the petitioner. Also heard Mr. D. Gogoi, learned standing counsel, APDCL. The present writ petition has been instituted by the petitioner praying for a direction upon the respondent authorities to consider his case for appointment on compassionate grounds. So the petitioner has also prayed for an interference with the rejection made with the reasons assigned for rejecting his claim for appointment on compassionate grounds by the constituted committee of the respondents. Full stop. The facts, the full stop, subpara. The father of the petitioner, late Mohendra Seal, while working as a SBO grade dash Roman 2 bracket TESD, comma, in the establishment of the Assistant General Manager, comma, Rungia Electric Division, comma, APDCL, comma, LAR, comma, bracket, comma, Rungia, comma, had died in harness on 12/5/2014. Also, the petitioner thereafter submitted an application on 28/5/2014 staking his claim for appointment on compassionate grounds. Also, the respondent authorities had thereafter consider the case of the applicant of the petitioner herein, along with other similarly situated applicants who had also applied for consideration of their respective cases for appointment on compassionate grounds. Also, on considering the relevant particulars pertaining to the petitioner and his family, this was by a committee,
Yes,
but the constituted committee arrived at drew the following conclusions. There are 77 tick to tick. So, the petitioner, by way of instituting the present proceeding, has assailed the said reasons assigned by the Constituted Committee, in addition to praying for a direction upon the respondent authorities for considering his case for appointment on compassionate grounds. Also, I've heard the learned counsel for the parties and also perused the material. As noticed herein above, the father of the petitioner had died in harness on 12/5/2014. Also, thereafter, the case of the petitioner being considered by the Constituted Committee, his application for his case was found not deserving. First up, the claim of the petitioner was found not deserving for consideration or appointment on compassionate grounds on the compassionate grounds, noticing the financial condition of the petitioner's family. First up, the said reasons have not been disputed. The reasons assigned by the Constituted Committee has not been disputed by the petitioner in the present proceedings. First up, the factual determination made therein with regard to the family pension as well as the retirement benefits drawn by the late Mohendra Seal has also not been disputed by the petitioner herein. First up, accordingly, this court is of the considered view that the reasons as assigned by the Constituted Committee towards rejecting the case of the petitioner herein for appointment on compassionate grounds would not mandate any interference. Having drawn the above conclusion, this court would now examine as to whether it would be permissible for this court to pass a direction today for consideration of the case of the petitioner herein for consideration of the case of the petitioner herein for appointment on compassionate grounds. Also, as noticed above, the father of the petitioner had passed away had died in harness on 12/5/2014. 11 long years have lapsed since the date of death of the father of the petitioner. The family of the petitioner is found to have sustained during last 11 years after the date of death of the father of the petitioner, and it is also noticed from the reasons assigned for rejection of the case of the petitioner that at the relevant point of time, the family of the petitioner was authorized a monthly pension of rupees 25,000 approx. Also, in the intention behind extension of the benefit of appointment on compassionate grounds being to immediately provide succor to the financial constraints faced by the family of a deceased employee on account of his untimely death. Such appointment is to be granted proximate to the period the deceased employee had passed away. First up, immediacy is the norm for effecting such appointment. Full stop. The long delay occasioning since the date of death of the father of the petitioner, this court is of the considered view that the immediacy is lost and the claim of the petitioner herein is held to be is rendered a stale one. So, in support of the above conclusions, this court relies upon the decision of Maidiba. Dismissed. Doesn't give any pleasure, but these things have to be sometime. A closure should be there.
I know that team says that 5% must has to be reserved, and they did not disclose how many posts.
You should have come in 2015 itself here.
Well, they did not consider that.
So now also you think, ask your client to think that it was never considered. Ask him to wait.
How like
Lordship, the selection.
So whether this review petition is required to be not required. Mr. Soikia, is this review petition at all required to be considered?
The whatever allegation.
No. Now this order, it goes in your favor. So nothing more is left. No, this order, this review is not going to help you. No, I can't pass an order to promote you. I can't pass an order. I have already passed. They have complied it in your favor. So whatever is there, you approach by way of a writ, by way of a whatever, contempt, whatever. No, that I can't do. That I can't do. That I can't do. Because this, if we hold, okay.
But on a wrong presumption, my lord.
Will kindly see your.
Afresh.
Afresh your.
Then everything will go. Mr. Soikia, you have got the order in your favor. Now the only thing is that a consequential order for promotion is to be issued. Let them do it. Let them do it. You make a submission to that effect. Make a submission. Mr. Ayat Soikia, learned counsel for the petitioner. By placing reliance on an order dated 9/6/2008 passed by the Director of Secondary Education in compliance with the directions passed by this court-wide judgment dated 6/9/2024 in WPC number 2776/2020 and WPC 6004/2022 submits that the
725 million.
Okay, 2/11/28. Sorry, so that is time. 2/11/25 day. Kilo. Submits that the selection process on being redone, the review petitioner is now found to have scored more marks than the respondent, opposite party number, respondent number. Here is respondent number 6. So accordingly, he submits that it is the petitioner herein who would now be required to be a review petitioner herein who would now be required to be appointed as the principal of the school in question. So he submits that the respondent authorities have not passed consequential orders after issuance of the order dated 2/11/2025. So he further submits that the review petitioner is slated to retire from his service on reaching the age of superannuation with effect from 30/11/2025. Accordingly, he submits that while he submits that he would not be pressing the present review petition in view of the order dated 2/11/2025 passed by the Director of Secondary Education Assam, but be granted liberty to approach the respondent authorities for passing consequential orders. Also, the said prayer made by the learned counsel for the review petitioner is reasonable, and accordingly, this court proceeds to close the review petition, being review petition number 201/2025, granting liberty to the petitioner herein to approach the Director of Secondary Education Assam for issuance of consequential orders in pursuance to the order dated 2/11/2025 passed by the said authority. First up, Mr. S. Borthakur. Mr. S. Borthakur, learned counsel for the petitioner with anger and he is present. Mr. S. Borthakur, learned counsel for the respondent number 6 is present, who submits that he also be granted liberty to take appropriate steps for challenging the order dated 2/11/2025. It is provided that it is open to either of the parties to take such steps for either compliance of the order dated 2/11/2025 and or to assail the same.
Your lordship, there is a, your lordship,
Subsequent to my.
No, that will now
that
that will now affect you. Anyway, take a chance. With the above observations and the present review petition stands closed. It was a matter, but
Supplementary list.
May it please your lordship. My lord, against the interim order for release of the vehicle, the
file-
forest department went to an appeal. The matter was disposed of yesterday, and we are asked to place this order before your lordship.
it was interfered.
Interfered because your lordship will see it's why it has been interfered. Because in the order, there was no specific of the numbers of the vehicle, and my lord, the general law has been referred therein. My lord. Okay. Your Lordship has seen, the order dated 99.
Now the entire writ petition has to be heard and disposed of. So give me a date. That we don't know, because 4 weeks time has been given.
Yes, we'll find.
We'll not go for 4 weeks. Next week, we'll have it on then 27th. 27th. Heard the Learned Council for the parties. The Learned Council for the parties have placed on record an order dated 12/11/2025 passed by the division bench of this court in writ appeal number 362/2025, whereby the interim directions passed by the coordinate bench wide order dated order dated 19/9/2025 has been stayed, with a further observation that the present writ petition be disposed of within a period of 4 weeks from today. Also, accordingly, as agreed to by the Learned Council for the parties, let us have it on 25th.
No,
Order though.
We are not we are giving you time, you file.
he should be concerned with himself.
That is for dumb. That is for dumb. We'll draw presumptions, huh?
They have
We have already filed. Mr. Gogoi, you are not Arunachal, are you? Can you demand an affidavit from an authority? Why should I direct? Okay, fine. You establish that. If they don't establish, you establish, we'll comply. 25th. As agreed to by the Learned Council for the parties, registry to list this matter again on 25th. All pleadings in the matter be completed before 21st, 21/11/2025 by the Learned Council for the parties.
Yeah, bless.
A copy to log at credible. This IA should be continued with, or we can close this IA? No. I had to anytime. I had to take a good one by it. Oh, yeah, what is there? That will come on its own. That is gone. Yes, madam. Item.
34.
You are M. Soikia. Miss MS N. Soikia, Learned Council for the petitioner. For the applicant. Who is there for the respondent? Also heard Miss M. Bhattacharya, Learned. None has appeared for the respondents. Post up. The present interlocutory application has been instituted by the petitioner praying for amending the prayer portion of the connected writ petition being WPC number 5706/2025. Madam, where is the part you want to incorporate? What is the part you want to incorporate? Prayer portion, what? You will have to bring that on record. Madam, you will have to bring in what you are there, what you want to incorporate in the application. Otherwise, I can't give you a blanket order, you amend the application. There has to be a specific. That you make that prayer item number, you have. Prayer 1, 2, 3. Now you make a prayer 4. That is not there. Withdraw this, file it afresh. Ms. M. Soikia, Learned Council for the petitioner, submits that a typographical error has occasioned in the present interlocutory application and accordingly prays that she be permitted to withdraw the same with liberty to refile. With regard to liberty to refile. Full stop. Prayer accepted. Interlocutory application stands dismissed on withdrawal with liberty as prayed for.
Item 18 to
Mr. Chaudhary,
I'm sorry, my lord.
no, it's okay. Mr. Goswami wants some time. Pleadings are complete. We'll not permit any further pleading. If they want to bring in further pleading, they'll have to file an IA. Mr. Goswami, you have to file an IA. Along with that, then we will allow you. Otherwise, these matters are ready. When do you want it for hearing? Okay, fine. No, these matters should not be kept. This have to be disposed of at the earliest, because tomorrow if we interfere, that will cause a problem to the administration. If we dismiss, the hopes they are carrying be dashed at the earliest. Either way, it should be heard at the earliest. Not December. It will not go beyond November. Let it be on 25th. Huh? 27. Mr. Chaudhary, any problem? As agreed to by the Lana Council for the parties, a registry to list this matter again on 27/11/2025. Full stop. Oh, fine. Full stop. And the parties have expressed urgency in the matter, and accordingly, it is open to the parties to make a prayer for a disposal of the present petitions on the next date of listing. If it doesn't come before me, it looks bad that I put an observation that it will be disposed of. Tintas, eh?
Your Lordship, petitioner was working as a junior engineer in the irrigation department, Lordship.
You are still in service?
No, Lordship, I have retired. I filed an affidavit, Lordship.
Then nothing more. Once you have retired, you have retired. Your case is 3F. Period has to be counted for seniority.
Absolutely.
Show me the law. Other than direct recruit, we have decisions of our court here, which says that period is not counted for seniority. That is the cases of Samiran and Burwa.
Lordship, 1950.
You see 3F, it's a temporary measure for 3 months.
Yes.
Yes,
Lordship,
after that, you don't have any right.
That affidavit government has said.
What mistake they have done? Why should this
I'm
court?
not on that mistake. Admitted this post 4 months. Now, if 4 months, Lordship, there is
That you have to go before the APSC.
FPS.
Okay.
That has not been done.
Okay, we'll do one thing. There is a violation, apparent violation of a statutory provision by the government. We'll say any service beyond 4 months rendered by you is null and void. Either way, we'll deprecate the government also. And because that same thing bars 4 months for you, we'll say any service after 4 months. No. Today, if you are saying that, the corollary would be that your service after 4 months is also not.
It has already been
Then you don't bring in those things. Show me that 3F period can be taken for seniority. Then we are closing it with that state. Mr. A. Bhattaji, learned counsel for the petitioner, after attempting to argue the matter at some length, submits on a query being made by this court, submits that the period of service rendered under Regulation 3F of the Assam Services (Limitation of Functions) Regulation 1950-51 cannot be reckoned for the purpose of assigning seniority to such appointee after his services are regularized. First off, he submits that the period of service rendered under Regulation 3F of the said regulations of 1951 is required to be excluded. Full stop. In view of the above position, he submits that the petitioner's 3F service not being permissible to be reckoned for fixation of his seniority, and further, the petitioner having also retired from his services, he would not press the present writ petition any further. Accordingly, he prays that he be permitted to withdraw the writ petition. Prayer accepted. Writ petition stands closed on withdrawal. Mr. N.N. Upadhyay, Learned Counsel for the Learned Standing Counsel, Irrigation Department, has no submission to make. For what submission? You're ready. You're ready for withdrawal, not objection to withdrawal. Any objection? No objection. Has no objection to the prayer made by the Learned Counsel for the petitioner. Accordingly, the petition stands dismissed on withdrawal. Mr. Upadhyay, sometimes you got to have some fun also. We were dismissing this matter, and then there was no representation. Why? Second time. Next time it is called, nobody is here, I'll dismiss it for default. There is. Okay, Mr. Sharma, we'll have it at 2 p.m. Any public prosecutor?
So inform them that,
Madam, all said and done.
yes, Lordship.
If you go by make your submission. Something has come here. The date of the incident is not there. Month of the incident is not there. There is no evidence that after the incident, when the girl tried to commit suicide and when the matter was disclosed to the parents. The evidence of the parents reveal that immediately on disclosure, the FIR was filed. Or there was a village meeting, then FIR, or FIR village meeting. Because dates are not there. So if the incident is proximate to the suicide, because it should be, suicide cannot be contemplated to have happened after, say, month or 2 months. It should be proximate to that incident. If that be so, the only steady evidence is the medical evidence, which says 16 weeks of pregnancy. Then how do you correlate with this? It's for the prosecution to say that, but you are an amicus curiae. What do you say on this? Don't be partisan here. You are an amicus curiae. You have to assess this court. Now, this is the query of the court. How do you answer to that? Either way. Because there is a doubt now whether that incident, when that incident occasioned, if that be so, the conviction under 376 may not be, it's doubtful.
Regarding involvement of that particularly
Person.
accused
person. Because if it is proximate to the filing of the FIR, then it cannot be 2 months pregnancy because there is no allegation of any sexual assault prior to that date.
And family members and others not knowing about or not her physical, etc., not, at least they should have come to that. Because otherwise also she is a disabled girl. So
No, that sympathy is there. But thing is, we'll also have to understand the circumstances. Because her evidence, if we keep it aside also, if from the circumstances this is plausible, then the conviction is correct. But
as it is only a circumstantial evidence, and such types of cases
we'll consider it as a circumstantial evidence because the girl's evidence will come in. But for that to be known, we'll also have to know the time factor involved. You please inform anybody, we'll have it at 2 o'clock. Also ask them to go through, there is a paper book, so no problem. They don't have a paper book, kindly give it. So just inform this query also,
Lordship.
either to Mr. Goswami or Mr. Sarma or Ms. Bora, anybody. You please, they might be in some other court, please do so at 2 o'clock. And you also examine this.
Page 57, Lord.
Page
57. Yeah.
yes.
The depends on which come to the conclusion is 56, Lord.
Are still in service. Only the pay. Yeah, getting pension also. Now, what is the period of absence?
Lordship from 7/1/2019, 5/1/2021.
Because
Is 54, Lord.
any order of suspension? And did you reply to this immediately?
Yes, Lordship.
Okay. And when did you join back? After the proceeding was initiated?
No, Lordship. Period. I have,
No, 7/1/2019.
yes, Lordship.
When did you join back?
After the impugn order, Lordship, then only they have allowed to.
That means you were not in service, you were not doing any job on 12/10/2020 when the show cause was issued.
I was not allowed to join. Right. In that period, I have applied for 3 times.
So what is your ground, first ground?
The first ground is, Lordship, this amount to admission, Lordship,
Okay.
cannot be acted upon, and therefore my right be heard is prejudice, Lord.
Okay. Page 56 does not support page 57. Right? Next.
15/9/2018 to 6/1/2019. I was
15?
15/9/2018
2019. I was absent due to illness.
Regularized.
Yes, it was regularized on recommendation of the medical board. And even after that, immediately on 7, after recovery, I have applied. They have not allowed. The nothing is there, Lordship. Concerned officers noticed that may not be allowed to join. Thereafter, medical report was there on recommendation of the medical board. It was regularized. Then at that time, they have not allowed me to join.
You rejoined on 7/1/2019, but your joining report was not.
Accept.
Where do I get that you had submitted this on 7/1?
And that is 32. Page
Page?
33 is the original.
32. Where is the endorsement?
Page 33, Lordship. Top at the A, not.
Who made this endorsement? No, it is 2AE. Somebody else has made this. Maybe commissioner.
Only on recommendation of the medical board, that period was regularized. Lordship,
That is the earlier period. Period prior to 7/1.
yes, that is page 44. After regularization of that period, Lordship, I have again applied, stating that I may be allowed to join.
When did you apply?
It was 6/5/2020.
5?
2020. Page 45.
What happened thereafter?
They have the notice to appear and attend for the officials. So he appeared and thereafter, Lordship, on 17/8/2000, again he applied.
After 45, it is 48. Then
One, Lordship.
yes.
That is 17/8/2020, Lordship. Repeatedly asked them, paid them for allowing me to.
Then the proceedings start.
Yeah.
So where is the regularization order of your leave?
Registration order. So it is page 44.
That much only? Yes.
But these are some judgment.
What is the judgments you want? What are the judgments you want to rely?
Or acting on the basis of the admission letter. It should unambiguous.
Judgment is required. Yes. Then all are because of that.
That Lordship, one is from our High Court, Lordship.
So, is there a charge to that effect in the show cause? No, is there a charge to that effect in the show cause? Then forget it. I thought Mr. Dotto would point that out. You can come straight to page 66. Last line onwards. Page, no, 66, your internal page 2 of your affidavit. Have you got it? See the manner in which you have dealt with that application. Be that as it may, now you come to page, internal page 6 of your affidavit. The internal page 6 is Annexure A. To clause 4, why he was not allowed. You did not allow, he was ready to work. You did not allow. So now you cannot penalize it. No, one thing, beyond the show cause, how can you allege absence? Absence would be till the date of the show cause. Huh? It cannot be beyond that. But now you come to the show cause, you come to your order at page 57. Has been admitted by. Show me the admission. I'm there in 56. Show me. This is writing a way of writing English. Where is that? I admit that. Categorical. No. He might have said that that allegation is there. He wanted to write English to his peril, but he has not admitted that I admit the charges. Mr. Bora, this will require an interpretation. If it is an interpretation, then an inquiry is must. That much this court understands. He has not admitted. That is British English. British English, a peon writing. You should not have put him into that position. He's a peon only. He's not a graduate in MA in English, honors in English. But whatever he could, somebody had written it for him. He also, or he signed in as miss. So this much GMC, the mighty GMC against a peon, if it acts in this manner, how can this court close its eyes? That is creating problem for him. We are interfering, give him everything. That this period, that increments would come down, no? Notionally fix it for the period he has not worked. Mr. Doctor, notional fixation. What is the period of absence?
That's what it was. 7/1/2019 to 5/1/2021.
20?
1.
We'll pass the order in the second half. DD wasn't withdrawn. Yes, who is appearing for the respondent?
Again, my lord, all brief.
Yes, Mr. Pegu.
For the earlier judgment, the court has
Show me that you had held a departmental proceeding after show cause, after the anything, then come to a conclusion that there would be a penalty. Okay. Your simple case is that that notional increments were not given to you.
Yes, my lords, because I was kept out of employment by them. The principle or no play, no pay is not that straitjacket. It has exception.
Yes, Mr. Pegu.
my lord.
Your affidavit will say many things, but where is the actual thing? His order was interfered with. Immediately he is reinstated. On reinstatement, everything stands condoned. Thereafter, you do what you want. You have not done that. Show me that his pay was fixed by providing to him, at least even notionally, the increments for the period when he was not there. Mr. Gogoi,
My lord.
that is the only grievance you have?
Yes, yes. Like I have decisions, your lordship. I have decisions. Like in one case, I was on the receiving end.
That sometimes.
No, at that time I learned. this.
Giving, sometimes you also got to receive.
Yes, no, it helped me, my lord. All judgments has been discussed here.
Gauramma.
Gauramma discussed this Dipali too. And then Dipali Gundu Sorvase, PVK Distilleries, EK Bhaskaran. And another one is Mintu Core, my lord, our court, my lords.
Yes.
I was of the opposite.
No. That is what I want to. Page 28.
29 last para, my lord.
28 last para.
In the event
In the event you want to do, it's up to you, but the order stands set aside. That means order is set at naught. The whole period get regularized. Need not be once the order is held to be illegal, everything goes.
That
Where
also,
is
my
the
lord,
further requirement? Where? Where is that? It was only a summary proceeding held, not an inquiry.
para page
Not an
20, I
inquiry.
was again confined to some like reserve clause kind of thing.
20 days.
And it is
20 days. That is different. This court gave you liberty to grow for a full-fledged inquiry. But you have not done that.
and in para page 10, they said they had forwarded this to some DG. They
Now, where
filed
is
in-
the
in
fixation?
fixation, my lords. Page 32 of the
So this is the story. Now, Mr. Gogoi, should we go before more than what you have prayed for before the authorities?
Leave it to lordship.
No. Why leave everything to the court? I'm asking a question only. Give me an answer.
If possible, yes.
What is the prayer you made in page 39? You know to read Hindi?
Yes, my lord, I know. सेवा में निष्कासित किया गया था परंतु आदेश कार्मिक के अनुपस्थित अवधि के बिना
को बिना वेतन के साथ सभी
Subsidy
लाभ
लाभ
देने के लिए निर्देश दिया गया है. Right? This is your understanding. Why should we understand it in any other? Not getting any pay for that period, but I'll give you the full benefits. Yes, Mr. Das. The petitioner's interpretation is before the authorities that my dismissal order has been set aside. Reinstate me without wages for the period not worked, but with all other consequential benefits. But there was no direction from this court to. After 56 will come in.
54 or
54.
54.
54.
54.
That will be entered into everything.
But he does not want it. What can I do?
Any other?
No other prayer.
No, 54-3.
No other prayer. And the authorities also did that. Now Mr. Pegu is getting ideas.
All final. My lord, prayer number 3.
No, your prayer here not. But what is your prayer before the authorities? Page 39. And they also acted in that manner only. How can we go beyond this? How can we go beyond this? So Das is also saying that is relevant. No,
No, he says not relevant.
no.
Not relevant.
I heard relevant. Okay. Mr. Give him everything. Pass the order today only.
Once
প্রথম order kita pass করুন তার সাথে matter লো second of all প্রথম
we should.
no
Publish.
then I'll have freedom to pass what I like.
Publish. my lord.
They're challenging the order, the dismissal order dated 7/12/2020.
Now tell me, how did you land up in the NRC?
In
Who
terms
has
of
taken you?
was-
Circle officer. He is within a circle. Huh? You are not even in the district. These are queries, Mr. Kolita. Don't get excited. You are not in the district. You are in Kamrup rural. Circle officer is of Kamrup Metro. Now, the authorities say that they made an inquiry with the NRC authorities. They have nothing. They have no record of about you. How did the circle officer know about this?
the respondent, government has filed affidavit.
Huh.
Government has filed affidavit. Government has admitted that he was discharging duties.
Show me.
Was two stand lordship.
Para.
Where affidavit filed by respondent of 5 lordship.
Who is respondent number 5?
Respondent of 5. Sub-divisional officer, Sodor India District of District Commissioner, Kamrup Metro. Comes with a court's order lordship. This affidavit has been filed. Is 185. Para 4. And regarding the allegation of the department that he is not competent officer, that's order lordship, that was also clarified in this
Where?
affidavit. I read from paragraph 4 lordship. That with regard to the statement made in paragraph 7 of the repression, the deponent begs to state that during updation of National Register for Citizen for the state of Assam, employees serving in various departments under the government of Assam were engaged for the from time to time. In that connection, the deponent begs to state that there was a notification by DD and Commissioner and Secretary to the government of Assam, so and so in the NRC. Based on that communication, a notification was issued by DD and in charge Deputy Commissioner Kamrup Metropolitan District by later number dated so and so, stating that all booth level officers under Kamrup Metropolitan District are as field level officers. It will not be out of place mentioned that at that time the post of the circle officer, Dispur Revenue Circle, was designated as ELO of Dispur LSC, and as per ERO handbook, the EROs appointed by the BLOs under the jurisdiction. In that context, the circle officer of Dispur Revenue Circle appointed the petitioner Santanu Kumar Deka as
So, all field level officers in a particular district are FLOs. Now, show me that you are in Kamrup Metro.
is 37 Lordship. Because his promotion, the senior resident at Mirza Lordship.
Pursuant to
Amranga.
the instruction. No. That is 37 is your engagement.
Yes, ma'am.
No, where is your posting? Where are you posted in your parent department?
Amranga Lordship.
Huh?
Amranga
Show me.
is 36. Tail number 3 Lordship. Santanu Kumar Deka,
Amronga is where?
Mirza Lordship.
No, where does it fall?
Kamrup district Lordship.
Kamrup Metro or rural? Okay, come to the affidavit filed by respondent number 5. So your case is based on that only. Now come to the affidavit filed by respondent number 5.
Para 5.
Just a moment, just a moment. Respondent number 4, sorry. Come to para 6, page 124. 1, 2, 3, 4,
And
fifth
the
line.
circle officer has no jurisdiction.
So and so. Then read further, read further, read further.
Circle officer has no jurisdiction at all to appoint BLO, and that too without any intimation and making any request to the department.
This is clarified by the respondent number 5, saying that all officers in a particular district are FLOs. Now read further.
So the petitioner is working in Amranga, which falls under the Kamrup Rural District, while the appointment order as BLO and his setup in Dispur Revenue Circle falls under Kamrup Metro District.
So just
Yeah.
clarify this.
Yeah.
Ultimately, we have 2 districts.
Yes.
How could the allegation is that you are in connivance with your
Lordship, is petitioners ultimately rightly or wrongly
No,
order
I
has
can't
been
help it. How did the
whether they have taken any action against
Mr.
the
Kolita, how did the circle officer know that Kolita is working in Amronga? I want him here.
the deputy
He is
commissioner?
a circle officer, only in a circle.
But the additional deputy commissioner also clarified.
Additional deputy commissioner is again Kamrup. He cannot have Kamrup rural.
Kamrup Metro Lordship.
Kamrup Metro, he can't be Kamrup rural. You are
Because the
Kamrup rural.
NRC duty was Beltola Lordship.
Where?
Beltola Lordship.
Ray, you are Kamrup rural.
He was performing.
I'm sorry.
Yes,
By affidavit of R5,
but
you are Kamrup rural.
statement Lordship regarding the respondent 4 and respondent 5 Lordship.
We'll give the benefit to the government.
And Lordship ultimately
What is the penalty? Dismissal. Appropriate.
the Lordship, he was performing that duty at that point of time.
You are a person who is habitual. Okay, come to the show cause.
Is 64.
Now, do you want further clarification that it is Kamrup rural? That you are posted in Kamrup rural? You want a further clarification? Come to page 42. Read that.
Is 41.
2. Read it. See, Manunya mean
from Amroga Borihat Kamru.
rural. And circle officer is metro.
Yes.
FLO is in a district, all officers. Okay, show me the Stokos.
Page 64.
50?
64 Lordship. Repeated with reference to the subject cited above, I am to inform recorded the updated service book of all the
This is the Stokos.
four onwards Sokos Lordship.
Yes, madam. This is the only Stokos. When? Where?
Lordship may come to
Lately, Lordship.
Everything got. I missed that out. Madam, where is the Stokos under Rule 9 which led to the passing of the impugned order? Impugned order is? You're a regular employee? Yes, madam. Come to page 52. Madam, we'll come back. We have 2 orders to pass. We'll pass that and then we will take up this matter. You connect back this to the section Rule 9 notice. That will do. Yes, Mr. Das. Reviewing authority increase the punishment.
Aspect of,
One
yes.
from that
Otherwise-
dismissal.
Initially, reduction of
Some pay, then
then
it was compulsory retirement,
Compulsory
compulsory retirement.
that's all in the job, my lord. So retirement is as good as dismissal from service.
But without any notice to you. Enhancement of penalty without any notice to you. Which notice
They have
required?
their
No, before that. It's a suo motu revision. Thereafter, he filed appeal.
yes, my lord. So communicate to me, but that did not contain any reason why they want to enhance the penalty.
You had submitted a reply also.
Yes, yes, I had submitted. Apart from that, my lord, absolute perversity, my lord. All the witnesses said that I
That
was
you were
there
not there.
when the loading was done, only on the basis of a contradictory statement of a driver, which was given immense credence by the inquiry officer.
Preponderance of probability.
How can it be, my lord?
How can it be not? They have done it.
No, you have to.
They have done it.
They can do anything. my
Yeah,
lord.
that's it.
That's
Then how can you say, how can it be? We'll have it.
really, my lord.
Heard Mr. U. Dotto, learned counsel for the petitioner. Also heard Mr. S. Bora, learned standing counsel, GMC. The petitioner, by way of instituting the hearing, has assailed an order dated 5/1/2021, by which the disciplinary authority had closed the disciplinary proceeding instituted against the petition by allowing the petitioner to rejoin his duties and by treating the period of unauthorized absence with effect from 7/1/2019 till the date of passing as unauthorized leave and directing that the set period for the set period, the petitioner would not receive any pay and further no increment, leave, DCRG, oblique pension, etc. would be and further that the period of unauthorized absence would not be counted for increment, leave, DCRG, pension, etc. The facts requisite for adjudication of the issue is noticed as under. Also, the petitioner herein where is the show cause notice, Mr. Doctor?
At page 54.
Petitioner herein, while working as a peon in the Guwahati Municipal Corporation, had remained on leave with effect from 15/9/2018. So, he continued to remain on leave till 6/1/2019. So, the said leave was taken by the petitioner, was projected by the petitioner to be necessitated on account of the ailments faced by him. Also, on recovering from the ailments, it is projected that the petitioner on 7/1/2019 had submitted a joining report before the Commissioner, Guwahati Municipal Corporation. However, the petitioner having remained absent from 15/9/2018, such joining was not permitted. Also, the petitioner having projected that he had remained on leave on account of the ailments suffered by him, the petitioner was referred to the State Standing Medical Board for examination. Full stop. The said board, on examining the petitioner, the respondent, but the board having also found the petitioner to be suffering from the ailments as projected by him, opined, gave a report in his favor. Full stop. Basing on the said report, the authorities of the Guwahati Municipal Corporation, were order dated 19/12/2019, proceeded to sanction to the petition half-pay leave for the period with effect from half-pay leave on medical ground for the period with effect from 15/9/2018 to 6/1/2019. So accordingly, it is projected that the period of absence of the petitioner with effect from 15/9/2018 to 6/1/2009 was regularized on medical grounds in the manner noticed in the order dated 19/12/2019. Full stop. After regularization of the set period of leave, the respondent authorities, the disciplinary authority of the petitioner, issued a show cause notice dated 12/10/2020, and therein alleged that the petitioner, after availing commuted leave with effect from 15/9/2018 to 6/1/2019, had remained unauthorizedly absent from 7/1/2019. So, the petitioner submitted his his reply to the said show cause notice on 15/10/2020. Also, the disciplinary authority of the petitioner, without carrying out any inquiry in the matter, provide order dated 5/1/2021 to hold that the petitioner herein, having admitted to the charge leveled against him in the show cause notice dated 12/10/2020, proceeded to close the departmental proceeding instituted against the petitioner in the manner noticed herein. So, being aggrieved, the petitioner has instituted the proceedings. Well, I've heard the learned counsel for the parties. Mr. U. Dr. Learned counsel for the petitioner submits that the due Dr. Learned counsel for the petitioner, by referring to the order dated 5/1/2021, submits that the conclusion drawn therein by the learned by the disciplinary authority that the petitioner had admitted to the charges framed against him is clearly perverse, inasmuch as in the show cause reply dated 15/10/2020, there is no such admission apparent on the face of it. Full stop. He submits that the petitioner had not admitted to the charge leveled against him, inasmuch as the petitioner had already, after availing the leave, after remaining absent on medical grounds, had submitted his joining report on 7/1/2000, but the same was not. But he was not permitted to resume his services by the respondent authorities themselves. Also, Mr. Dr. has further submitted that the petitioner herein had retired with effect from
31/1/2020.
31/1/2024 on reaching the age of superannuation. Yes, Mr. Chaudhary, what is there? Oh. Now, whether an appeal has been filed, what
They
happened to
say
the?
they have filed an appeal.
That-
I
that is a-
understand and notice there is a of about almost 300. They have as a counterblast. I
They have- Because there is a detailed description of that in the orders. So, should we wait for that? Would it be not prudent to wait for that, Mr. Chaudhary?
but appeal will continue.
But the only
But
thing is that
let
your
them
promotion
consider my
to
case, yes.
IFS.
Subject to the outcome of the writ appeal, let them consider my
But
case.
Mr. Chaudhary, that can be passed because IFS, that is again, it will be your prejudicial, because if that does not go,
Even under the
you know the case of Varsati Das.
Now 55.
You know the
they are
case,
supposed to do the
you know the
provisional.
case of Varsati Das. You finished it here, then only the thing got moved. Because if that is there, Mr. Chaudhary, it will be difficult for you.
But at least they should expedite their process, my lord. They can't keep us hanging like this.
Why don't you make a mention, ask your junior to make a mention of that matter, take it up and then finish it off?
Delay has not been condoned. 100 days. That's why
You need not be here. We'll fix a date if required. Just get somebody
You
from the
also
government.
can keep it for the no, my friend would be there
Ah.
next week, my lord.
But I'll do it. Let me also have
Yes.
their response. Anytime. You need not wait.
Keep-
Mr. Das, get hold of our government counsel, who is Mr. Nath, if required. Whoever is there. Illegally superannuated on reaching the age of superannuation. Also, he submits that on account of the stipulations made in the impugned order dated 5/1/2021, the petitioner has suffered prejudice and there is a reduction in the pension and pensionary benefits as authorized to the petitioner herein. Also, he submits, Mr. Dr. further submits that the petitioner being subjected to a departmental proceeding wide issuance of the show cause notice dated 12/10/2020, the petitioner could not have been held to be unauthorizedly absent till from 7/1/2019 to 5/1/2021. He further reiterates that the petitioner, having submitted his joining report on 7/1/2009 and the same not and he being not permitted to resume his services on the ground that his absence from 15/9/2018 to 6/1/2019 was considered to be unauthorized, however, the set period of absence having been authorized by the respondent authorities after receiving medical opinion about the ailment suffered by the petitioner herein, he submits that he submits that the denial to the petitioner to resume his service is clearly arbitrary. He further submits that the petitioner being willing to resume his services after being absent on medical grounds, with effect from 7/1/2019, and he being prevented from doing so by the respondent authorities, the petitioner cannot be penalized for the said purpose. Anything more? In the above premises, Mr. Dr. submits that the order dated 5/1/2021 would mandate an interference by this court. Mr. Bora, learned per contra, Mr. Bora, learned counsel for the respondent, submits that at the outset submits that the petitioner is an habitual absentee, and he has remained unauthorizedly absent for different periods of time over the years. First up, he submits that the petitioner, with effect from 15/9/2018, had remained unauthorizedly absent without informing about the reason of his such absence to the respondent authorities. He submits that the petitioner, on resuming his on submitting the application, the petitioner on 7/1/2019 on submitting his joining report, he was not permitted to join his services inasmuch as he had remained unauthorizedly absent from 15/9/2018, and the reason for such absence was not established. He submits that Mr. Bora submits that the petitioner, after being issued with a show cause notice, had submitted his reply thereto on 15/10/2020 and had, in the said reply, admitted that the allegation leveled against him in the charge sheet was true. Accordingly, he submits that the petitioner, having admitted to the charges framed against him, no error was committed by the disciplinary authority in concluding in the order dated 5/1/2021 that the petitioner herein had admitted to the charges framed against him. So he accordingly submits that he further submits that the disciplinary authority of the petitioner had leniently considered the matter and no penalty as such was imposed upon him. First, the only stipulation made in the order is to the effect that the petitioner, during the period of his unauthorized absence with effect from 7/1/2019, would not be entitled to any pay, and the period would not be reckonable for the purpose of authorizing to the petitioner increment, leave encashment, DCRG, pension, etc. He submits that admittedly the petitioner, having not rendered any service from 7/1/2019, he would not be entitled to any pay for the period till he was so reinstated in his services in pursuance to the order dated 5/1/2021. Also, in the above premises, Mr. Bora submits that the petitioner herein submits that the order dated 5/1/2021 would not mandate any interference. I've heard the learned counsel for the parties and also perused the materials. Also, it is an admitted position that the petitioner herein had remained absent without intimation with effect from 15/9/2018. Also, thereafter, the petitioner had approached the authorities with a joining report on 7/1/2019. Accordingly, the petitioner had remained absent from his duties, without intimation to the authorities with effect from 15/9 to 6/1/2019. Also, on the submission of the joining report on 7/1/2019, the respondent authorities did not permit the petitioner herein to join his services. Also, it is seen that the petitioner thereafter, it is seen that the petitioner along with his joining report had submitted a leave application form and a medical certificate, which was, however, not countersigned by the senior medical officer of the respondent corporation. Also, the petitioner having projected the reason for his absence to be on account of ailments suffered by him, the petitioner is found to have been directed to appear before the State Standing Medical Board, Assam. The petitioner on appearing before the the petitioner had accordingly appeared before the Standing Medical Board, and the board had opined in his favor. Also, basing on the opinion of the said medical board, the respondent authorities, by order dated 19/12/2019, had regularized the leave of the petitioner with effect from 15/9/2018 to 6/1/2019 on medical ground by granting to him half-pay leave. Also, subpara. The passing of the order dated 10/12/2019 would bring to the establish that the period of absence of the petition from 15/9/2018 to 6/1/2019 has not been held by the respondent authorities to be an absence to be unauthorized absence. Also, the said absence having been regularized has to be held to be on account of a justifiable reason. Also, having noticed the above position, this court would now examine the order, the show cause notice dated 12/10/2020. Also, they said show cause notice, the notice issued towards instituting a departmental proceeding against the petitioner with an allegation that he had remained unauthorizedly absent with effect from 7/1/2019 after availing commuted leave with effect from 15/9/2018 to 6/1/2019. Also, this court notices that the petitioner on 7/1/2019 had submitted a joining report along with a medical certificate and a the prescribed and a filled up and a leave application also in the prescribed format. Also, they said joining report was a perusal of the said joining report. It is seen that an endorsement is made therein by the respondent authorities to the effect that the petitioner be not allowed joining of his service as he was absent without any information. Also, the period for for which the petitioner was projected to be absent without information is the period with effect from 15/9/2018 to 2019. The said period having already, a third period as noticed herein above, having been regularized by grant of commuted leave on medical ground, wide order dated 19/12/2019, the said period cannot be held to be a period of unauthorized absence by the petitioner herein. Also, the steps taken by the petitioner as well as by the respondents herein in the matter, reveals that the petitioner with effect from 7/1/2019 was ready to resume his services. However, because of the doubt arising in the matter as to the reason for which the petitioner had remained absent with effect without information, with effect from 15/9/2018 to 6/1/2019, the joining of the resumption of service by the petitioner was delayed, and the petitioner cannot be faulted for the same. First up, the petitioner having resumed his services, having submitted his joining report on 7/1/2019, it was required of the respondent authorities to permit him to resume his duties, and in the event it was considered that the petitioner had remained unauthorizedly absent, it was open to the respondent authorities to place the petitioner under suspension and draw up proceedings. However, for the reason that the petitioner was absent for a particular period of time, the respondent authorities could not have denied to the petitioner a resumption of services. Also, having noticed the above position, this court would now examine the order dated 5/1/2021. The said order being relevant to the issues arising in the present proceeding, the said order being under challenge in the present proceeding, the same is extracted herein below. Page 57, A to A. A perusal of the said order would bring to the forefront that the punishment imposed upon the petitioner was so done on a conclusion being reached by the disciplinary authority that the charges of gross negligence of duty, indiscipline and insubordination has been admitted by the petitioner in his show cause reply. As noticed herein above, there was no inquiry held after the issuance of the show cause notice dated 12/10/2020 and prior to issuance of the order dated 5/1/2021. First, the above being the stipulation made in the above being the conclusion drawn in the order dated 5/1/2021 by the disciplinary authority, this court would now consider the show cause reply submitted in the matter by the petitioner on 15/10/2020. On a perusal of the show cause notice, this court finds that the petitioner had made the following contention. B2B, page 56, B2. On a perusal of the said same, this court is of the on a perusal of the contentions made in the show cause reply, this court is of the view that the statement made therein to the following effect, C to C, cannot be construed to be an admission by the petitioner with regard to the charges leveled against him in the show cause notice dated 12/10/2020. Also, the petitioner herein is found to have signed the said show cause reply in vernacular, whereas the show cause reply has been typed out in English language. Also, the petitioner is a peon and is not and cannot be and knowledge cannot be attributed to the petitioner about the niceties of a departmental proceeding. Also, there being no clear admission on the part of the petitioner with regard to the charges leveled against him in the show cause notice dated 12/10/2020, such admission not being found by this court, in this not being found by this court in the show cause reply, the respondent authorities could not have proceeded to impose upon the petitioner the punishment as imposed by the order dated 5/1/2021 without first holding an inquiry in the matter, and by inquiry in the matter by giving due opportunity of hearing, by providing all opportunity to the petitioner hearing. Also, this court not having found any admission with regard to the charges leveled against the petitioner by the show cause notice dated 12/10/2020, this court is of the considered view that the conclusion drawn by the disciplinary authority of the charges being admitted to by the petitioner in his show cause reply, would not mandate an acceptance, and accordingly, the impugn order dated 5/1/2021 being solely based on such conclusion of admission by the petitioner of the charges leveled against him, the same would mandate an interference, and accordingly, the order dated 5/1/2021 stands set aside. Also, the petitioner, having submitted his joining report on 7/1/2019, and as noticed here and as concluded herein above, the respondent authorities without either placing the petitioner under suspension, could not have prevented his joining in his services, this court is of the considered view that the petitioner being available for joining in his services, the period of his such forced absence from duties with effect from 7/1/2019 to 5/1/2021 has to be regularized as on duty, and the consequential monetary benefits flowing to the petitioner on account of such regularization of his services as on duty with effect from 7/1/2019 to 5/1/2021 be released to him. The areas of pay now required to be released to the petitioner with effect from 7/1/2019 to 5/1/2021 be so computed and released to the petitioner along with his due annual increments within a period of I'm coming to that. Don't worry, I'll take care of that also. But this much, how much time will you require? Within a period of 4 months from today. So, on the computation of the pay and allowances of the petitioner with effect from receivable by the petitioner with effect from 7/1/2019 to 5/1/2021 is so made by the respondent authorities, the respondent authorities within a period of 1 month thereafter shall recompute the pension and pensionary benefits are now receivable by the petitioner on account of the payment of on account of the increments drawn by the petitioner for the period with effect from 7/1/2019 and till 5/1/2021, and the consequential increase in his pay and allowances on the date of his superannuation. The areas of pension and pensionary benefits now due to the petitioner shall also be released to the petitioner along with the areas of pay due to him within a period of 4 months from the date of receipt of a certificate. Anything more? With the above observations and directions, the present writ petition stand disposed of. I would like get the orders by Monday because they'll have to type it out. Yeah. तो जानी के तुम्हार खबर पठा दे तो जा He was a constable, no? Nobody prevented you from holding as a de novo inquiry or a fresh inquiry. This court gave you that liberty. You did not take it. What can we do now? This court is the last court in disciplined officers matters. But in such cases, this court cannot close its eyes. We'll have to. I see. Okay, we'll take it up after some time. Let them come. We'll hear a matter in the meantime.
25. 25.
Why did we stopped because it was 1 o'clock? Where is Mr. Coulter? So you assist me in this matter now. On the prayer of the Learned Council, Mr. Kalita had made his submissions in the matter. However, the same remains inconclusive. Registry to list this matter again on Himantari. Twenty-one. 21 will 20. Okay, 20.
After some time, Lordship.
After some time, after 2 minutes. 2 minutes. Moment the watch cross 2 minutes. You have not read the file. Huh? Have you read the file? Okay, we'll take it up after some time. Yeah, it file. Yeah. But Mr. D. Gogoi, Learned Counsel for the petitioner, also heard Mr. G. Pegu, Learned CGC, appearing for all the respondents. All the respondents. The petitioner has instituted the present writ petition praying for the following reliefs. Page 14, A to A. Also, the facts in brief requisite for adjudication of the issue arising in the present full stop. The petitioner herein, while serving as a constable, bracketed general duty, comma, CRPF, Central Reserve Police Force, bracket hereinafter referred to as CRPF, at Sinki View, Itanagar, comma, was detained in connection with a criminal case on 20/2/2014. Also, the petitioner having remained under detention for more than 48 hours, comma, he was placed under suspension / deemed suspension with effect from 20/2/2014. Also, thereafter, a departmental proceeding was instituted against the petitioner herein by issuance of a memorandum dated 10/3/2014. Also, the said memorandum said departmental proceeding was continued, and on the inquiry report being submitted on 23/4/2014 by the inquiry officer, comma, the disciplinary authority proceeded with order dated 9/7/2014 to impose the penalty of dismissal from service upon the petitioner herein. Subpara. The petitioner, you preferred an appeal then?
Yes.
An appeal was preferred?
Appeal is
The appeal preferred by the petitioner in the matter against the order of his dismissal from service also came to be rejected. So the petitioner, Sapara, being aggrieved by the order of his dismissal from service, comma, assailed the same before this court by way of instituting a writ petition being WPC number 3157/2006. This court, the coordinate bench of this court, upon appreciating the materials coming on record in the said proceeding, proceeded with order dated 25/3/2021 to interfere with the order of dismissal from service of the petitioner. Also, having interfered with the order of dismissal from service of the petitioner, comma, a liberty was granted to the respondents to hold a fresh inquiry against the petitioner in accordance with the CRPF Act and rules. Full stop. The conclusion, the direction passed by this court, by the coordinate bench of this court, while the order dated 25/3/2021 being relevant, is extracted herein below. Para 11, page 26. Oh, sorry, para 17, page 28. Full stop. It is seen that the It is seen that the respondent authorities, in pursuance to passing of the said order by order dated so and so by the coordinate bench of this court, comma, and on examination of the order, decided not to prefer any appeal against the same and to comply with the directions passed in the matter. Also, the petitioner accordingly was reinstated in his services. Full stop. The respondent authorities, after the reinstatement of the petitioner, had drawn up a proceeding against the petitioner on 9/7/2021, and on conclusion thereof, the petitioner was imposed with a punishment of undergoing 20 days confinement to the line in terms of the provisions of the CRPF Act 1949 and the rules thereunder. Also, the petitioner, having been reinstated in his service, noticed that he was being released his pay and allowances at a lower stage than that authorized to his batchmates, who were also inducted into the force along with him in the year 2007. Full stop. Being aggrieved, the petitioner has full stop. Full stop. The learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that has submitted that the petitioner, on being reinstated in his service, he was required to be reinstated in his service on interference being made by this court with the order of his dismissal, he was required to be released his pension, his pay and allowances for the period he had remained out of service on account of the imposition of the order of dismissal upon him. Mr. Gogoi has further submitted that the respondent authorities had not passed any order towards denying the petitioner his due pay and allowances for the period he was required to remain out of service on account of being imposed with the penalty of dismissal from service. He submits that in view of the fact that the petitioner had to remain out of service on account of the imposition of the penalty of dismissal from service, which was interfered with subsequently by this court, the petitioner cannot be denied his back wages and the period of his such absence, forced absence, has to be regularized as on duty. Much only, anything more? Also, he submits that the respondent authorities, in the above premises, he submits that the respondent authorities be directed to release to the petitioner his due pay and allowances for the period he was required to remain out of service on being imposed with the penalty of dismissal from service, and on his resuming services after the interference with the order of dismissal by this court, his pay be so fixed up by reckoning also the increments he would be now drawing for the period of his absence. Per contra, Mr. G. Pegu, learned counsel for the respondent, has submitted that the petitioner herein, having not served during the period after imposition of the penalty of dismissal from service, and this court having interfered with the order of dismissal only on a technical ground, the petitioner herein would not be entitled to any back wages. He submits that the respondent authorities had complied with the directions passed by this court and no fresh departmental proceeding to the allegations existing against the petitioner herein. He submits that only a proceeding was instituted by the respondent authorities, and basing thereon a punishment of confinement for 20 days was imposed upon the petitioner. Mr. Pegu has fairly submitted that no order was passed by the competent authority towards denying the petitioner his due pay and allowances for the period he was placed under suspension, he was for the period of absence on account of being imposed with the penalty of dismissal from service, and further, and that no order has been issued towards holding the set period of his absence, forced absence, to be not reckonable for the purpose of computing his other service benefits. Also, in the above premises, Mr. Pegu submits that the order submits that the petitioner on his resumption, on resuming his services, having paid all due benefits by also taking into consideration the his absence from service, comma, by taking into consideration that he, during the period after imposition of the penalty of dismissal from service, had not discharged any duties in the force, comma, the grievance of the petitioner raised in the present writ petition would not mandate any consideration. এখিনি মাৰি দিয়া বাকিখিনি মই দি আছো মাৰি দিয়া প্ৰতিভা আছে না এইটোকে মাৰি দিয়া we are allowing it. I'll pass the order. We are allowing it.
All right.
Ines, what timing it? Mr. Das, give me 5 minutes.
Fine, fine, no problem.
Yes, Mr. Gulda.
And court matters. This was of 2015. And on the basis of this, it was earlier disposed of lawsuit. On the basis judgment passed by this honorable court, they have filed another writ petition lawsuit. So that's number is lawsuit 314 of 2020.
What is that writ petition?
This writ petition lawsuit,
No. The other pending writ petition.
pending writ petition lawsuit, filed 15 writ petition, it was disposed of, but the order was not lawsuit complied with. Then lawsuit after two, they have partly complied with the order. There was some imposition of fine was there. They have paid the fine, but they were not reinstated in their service. Filed again writ petition to that is still pending. Now lawsuit they have filed.
If I allow or if I dismiss this writ petition, that will get answered by its own. Yes. What is your case?
Petitioner lawsuit applies to worker and pursuance of the lawsuit advertised.
What is the Anganwadi center?
Dakshin Pichal Anganwadi Center.
Where do I get it?
Page 50 is the
Page 50. In Pithial.
first lawsuit.
Where is this? Which is the ICDS project?
Dokwakhana lawsuit. Dokwakhana ICDS project.
Yes.
Two is lawsuit will find at page number.
How many petitions are here? How can you, how there are two Anganwadi centers, that means, or Anganwadi helper and Anganwadi worker, same. Okay.
Only thing is,
No. Anganwadi centers are per se one.
yes.
And these two persons are for the same center. Or then how can you join together?
In this petition, some other person approached this court while we were working lawsuit. While this petitioner were working their respective posts, some other person who.
Okay, we'll
Yes.
come to that.
Yes.
Now, where is the petitioner number 1, serial number 2,
Yes.
right?
Devoti Dole.
Deboti Dole. Who is the Anganwadi helper here?
This was the first one.
Huh?
One.
Anganwadi helper. That means Noyanmoni Hazurika. Huh? AW. H. And
My order dated 17th.
then there was a
First
review
one,
file.
yes.
And the review has restored this matter. So it's a 15 matter. We'll have to get it out of the way. Okay. Then Deboti Dole is Anganwadi worker. Right? Then
Then
what is her center? But she is also shown here as Anganwadi worker.
Is a center is different, Lordship.
Huh?
Center is different.
How can you club?
Jairampur,
How can you club
I will
to?
come to that point, Lordship. Because on the basis of the order passed by this honorable court,
Be that as it
Yes.
may, your selection is somebody else, one selection is somebody else. A1,
Yes.
B, B1.
election process is the same, Lordship.
Be that as it may.
Yes, but-
There are two centers, two proceedings. Why should we consider this for the two? We'll limit it to one. Okay.
Lordship will find the selection page 9.
What is 52?
Page 52, Lordship. This was a Lordship minus of a meeting, but Lordship after was held by the selection committee coming to that. Page
50?
59.
59.
Of this my 12. You'll find a page 60.
What are the names of the other two petitioners, private respondents whom you have made here? In the earlier round who had,
Earlier litigation, they initiated that.
okay,
First one.
what are their names?
Kulkumari Pegu and Golapi Hazarika. Respondent number 6 and respondent number 6.
Kumari
Pegu,
and
Golapi Hazarika.
Fulkumari Pegu is against whom? Noyanmoni.
This is petition lawsuit. In this case, we have made them party only on the grounds that lawsuit they were appointed cancelling our appointment. Other first proceeding lawsuit were not made party in the said petition. Filed by Fulkumari and Golapi, we are not made party, although we are working in the said post. That is the
Fulkumari is against whom? Noyanmoni or the other one? Dole. Okay, you go as per your thing. Okay. 59. Okay, 59.
page 60 lawsuit. You will find a
Recommendation.
recommendation. Cell number 9 is the worker. The basis of this recommendation lawsuit is petitioner were allowed to work by their engagement.
Where is the order?
That order. Devoti Dole.
Helper. Now, where is the selection as Anganwadi helper? Noyanmoni Hazurika. 69.
60.
Huh?
60.
Oh, you took me to 69. 69 is what?
Lordship,
No, 59.
Yes, 15 starting, Lordship, 60 is related. Yes, 69. The
Okay, Dakhin Pitha
document
Hall,
official, yes. Is helper, Lordship.
Perumpur worker. Okay, 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 okay.
The
Then,
basis of these two order, Lordship, is 68.
mm,
Thereafter, Lordship, some person who were also Lordship participated in the said process and who failed, they have approached this court. At page 70 is the order, Lordship.
Hmm.
Interestingly, Lordship, although these petitioners were working, they were not made party in the said petition. Behind the back of this petitioner, Lordship, this pass and for the court whether they were working or not, Lordship. There was passed at page 71, Lordship. Lordship, will
where is this report, inquiry report of 29/1/2011? Where do I get the names of Fulkumari and Gulapi? Yes, Mr. Kulta, where do I get the names? Okay, I got it.
yes, Fulmai Pegu's name is page serial number 7, Lordship. Fulmai Pegu's name is there. Golapi serial number 7.
Fulmai Pegu.
Pegu, Lordship.
So, have you challenged this inquiry report?
Actually, that is why I'm saying, after passing this inquiry report, the CDPO has rejected this report and passed the fresh report at page 59. Recording of the meeting, page 59, just I'm reading, Lordship. Recording of the meeting.
This is not correct.
Page 59, Lordship.
60.
Yes,
The residential status cannot be the revenue village. It has to be the coverage area of the Anganwadi
we have
sector.
finished our certificate of issued by Gambura also, Lordship, whether we belong to that village or not.
To village you may be, but are you within the
That has to
coverage
be
area?
ascertained by the Lordship, by inquiry officer only. Because
That inquiry officer thing is already done.
yes, that is a page, this report, subsequent report is there, page 15 and page 16. The first report.
Within the area of the center, and
Yes,
this is
within the area of the
village.
center.
And that
Within
is
the area of the center.
where? Where do I get it?
No, that is why, Lordship, the second.
So do one thing.
Yes.
We are you have an interim order here.
Order is here, Lordship.
Interim order. Who is working now?
Not here, Lordship.
Who is working?
Now the person who first approached Lordship without in.
Those
making
two,
us party,
they'll
Lordship.
continue to work. You approach the director, director will, these things is not for this court to go
Lordship,
into.
First thing, see, we were working. So,
You were working, whether
Yes.
you are within the center area,
Yeah,
whether in the, that you
if
go
we
and
are
establish.
Assuming that we are not in center, at
Uh.
least we should have been given a notice that.
Forget it. If you're not in center, you're not in center.
No, Lordship cannot, because we were working in the same post without making us a party.
If I cannot,
No, Lordship, that.
you know what to do.
Saying about the CDP conduct, Lordship.
Like,
That is why, Lordship kindly see, that is why the first court, this honorable court has imposed penalty upon these officers, 10,000,
fine.
10,000.
Also, Lekha, heard Mr. J. Kolita, Learned Counsel for the petitioner. Also heard
This is going to
Mr.
dispose of this matter.
I'll dispose it of.
Lordship, can I reply to this affidavit? Because first time I'm appearing in this case. Lordship, can you see that my name is, last week I filed.
You have made your arguments.
No, Lordship, kindly see, all these are fake documents. Kindly see, Lordship, last occasion I have.
That's why I said, go before the authority, prove the
We
fake.
have to suffer because, Lordship, we are appointed.
I'm giving you a peneke. You go before the fact-finding authority. I'm not here to find out facts. Am I? Then disputed whether you are here, whether you are here.
Lordship, kindly may call for the.
We will not call for anything. You just see the order. You go before the director. We'll.
Justice to this petitioner, because, Lordship, because the first petition when filed, we were not made party, Lordship, and without making us a party, this honorable court on.
Show me that
Yes.
you are within the center area. Show me.
Center is
Show me one document that you are within the center area.
we have an certificate.
I'm not. I'm a report.
Report was not called for, Lordship, initially,
Then
only certificate.
The circle officer's report is that you are in the village. Village is not the, you show
Lordship,
me
that is why
that,
first.
okay, you show me that you should be within the village,
Then,
not
Lordship,
within
give
the,
me 1 day time, 2 days time, so that person come from Lakhimpur. Lordship, give me 2 days time, pending since 2015, at least 2 days.
oh, that is why should it keep pending
That
from
is why I'm saying-
2015?
Because that issue was never arose, that we are not belongs to the vicinity of that center. We certificate. has been
Mr.
issued-
Kolita, go before the authority, get your thing done.
No,
We are not
kindly-
here.
No, Lord, there is no issue to go to the authority, but thing is that. Lordship,
You
we have
don't
been
go.
deprived.
I'll direct you, don't go, you go upon appeal.
Lordship, kindly see the first order of this honorable court at page 70. Whether in this situation, this petitioner make a party. Now, if we are not make a party, how can we, Lordship, bring on record that whether you.
Why don't you go on appeal against that? You should have gone immediately on appeal or a review. Mr. Kolita, you have not been made a party.
Yes.
That is not the end of the matter.
That is
You
why-
could have filed an appeal, you could have filed a
But
review.
Since we have not been made party in first proceeding and our service
You
has been
could have,
terminated,
even when you came to know about it, you could have gone up on appeal.
immediately you have come, Lordship.
Not on a writ petition, on an appeal
Appeal.
against that order. Can I set aside a coordinate bench's order? Can I go over it?
Coordinate base has never directed to terminate our service. Lordship, kindly, that is what I'm saying, page 71.
When the appointment is called for, the consequence would be termination. Consequence would be termination.
To whom, to Lordship?
This termination is not by the respondents. It's in response to an order passed by this court, compliance of the order. You had any grievance, you could have advised the client to file a appeal
Now-
or a review, finished.
Now, thing is that, Lordship, the pleadings of the writ petition, whether any grievance were made against this petitioner. If
That
we-
is not for me to look into, Mr. Kolita, today.
No, that is-
I'm not here to arbitrate between two orders.
Case was, Lordship, decided long back in 2019.
2019 complied with.
2019, that is why, Lordship, in 2019, our writ petition was allowed. So, Lordship, then that order may be restored.
Which one?
The first order passed in this court.
When was it passed?
I think it is 2019, Lordship. Coordinate bench has passed this order, Lordship, may kindly restore this order.
Do you want me to restore this order? Show me the grounds for restoration. Law. When an order is already withdrawn, already reviewed, how can I?
On the grounds, Lordship, if Lordship can see the review petition, only on the grounds that since there are 4 persons and 2 procedures.
Mr. Kolita, you are a seasoned player. These are not the arguments which is to be made here.
Otherwise, Lordship, my petitioner has to suffer.
You will have
Because-
to.
No, how, Lordship, after 10 years, Lordship, because we are
You
working.
are suffering for the last 10 years.
No,
2019 onwards, you are suffering.
15.
15 onwards,
Yes,
you are
yes, sir,
suffering.
Because
Continue.
in the year 2015, immediately after termination of our service, we approached this court.
We'll take it up. I think we'll have to hear you a little bit more. We'll take it up after some time. You get your breath back.
Yes.
Get your thought process back.
On
We'll take it up
Monday-
after
on
10. No, today.
Monday, Lordship, so that I can bring at least the documents that we are.
I'm sorry.
Fine, Lordship.
Yes.
16.
Yes.
I think there is some result list. As
What is the basis for holding that he is guilty,
yes, Your Lordship.
other than the statements made under 161? Any admission in the inquiry?
No, Your Lordship.
Then-
Admissions.
Then what is the basis? 92. Okay. Okay, 92. What is there in 92? Hmm. Hmm. Now, where is that exhibit? Where did you exhibit that Caesar list in the inquiry? Then how can you establish this charge? How can were these two officers called in the inquiry? Had these two officers who made the Caesar brought to the inquiry? Yes, Mr. Counsel. Whatever be taken away, but there is a law in this country. You can't just hang a person. Some semblance. Somebody said somebody and the inquiry officer will hang that person, hold that charge is proved without even that material coming before him. Yes, Mr. Counsel.
Potential information here.
You please take your seat. Please have your seat. Yes, Mr. Song. Show me the basis for holding that the petitioner had with preponderance of probability committed this. It cannot be oral. Who had made this statement? MW1. Show me his statement. Page number 20. Which is the part? That I've got it. Where is the relevant portion?
Is the list of the
Where is a cross? Where page? Page? Or cross? No, where is her cross? Where do I get it? Ah, that is the question she has put. Come to page 25. Down. 1, 2, 3, 4, 5, 6, 7, 8. Do you have a signed copy of the list of articles that you said to be confiscated from my possession? No. On what basis you're stating certain articles? The incident occurred not only in my presence, but also in presence of my second man. The incident has been officially recorded in MEX4. You are lying. I deny that articles. Do you have any documentary? MW1 is lying to so and so. So she asked a very relevant question. What was the material? What happened to the criminal case? What happened to the criminal case?
We have
No charge sheet may have been filed. What is this MEX4?
Four is your lordship. Page number.
No police officer was brought in the inquiry. Okay. Yes. We come to page 22. MEX4 was proof of the inquiry. And that MEX4 reveals your deeds. So what do you say? You were found to be involved. You are a bank employee. Question of loss of confidence is there. Account numbers will not be seized. Account numbers, that papers have been seized. And that letter, it's very clear, MEX4. That establishes the case against you. So, you have not.
There is no such confession as is stated in the MEX4. Here, when she was interrogated, she says that she had been giving acid details on various customers to an unknown man.
Okay. And the account details are of the numbers which were found in your bag. And the authority branch manager has given that to the police. What is that MEX7?
That is an intimation. MQ50.
This is by the police. So, what do you have to say? The counsel, what do you have to say?
The allegation is concerned. Just for, just the allegation, nothing has been.
This head requires something more to go inside. Very hard-headed. Give me that something extra. You seem to be not prepared. Prepare. Prepare. We'll take it up. Prepare. Yes, next. Anybody? Oh. Mr. Borua, you had the records with you. You have the record with you. Everything said and done. I've told Madam also. Now, the only factor which we have here is the pregnancy of the girl. On the date when she was examined, it was found to be 16 weeks. Now, if we go back 16 weeks from that day, we will arrive at a particular date, roundabout. Now, you come to the evidence of the victim girl. She says that this incident happened. She came home. She did not disclose to anybody. But she was so troubled by that, she attempted to commit suicide. And while committing suicide, while trying to commit suicide, mother got her. Then this story came out immediately, either before the FIR or after the FIR, there was a village meeting. Be that as it may, there was a village meeting. Now, what is the proximity of this thing? Because mother knowing and the FIR filing are very near. But the incident and the mother knowing, where is the material to know when the mother knew or after how many days the mother knew? Because if it is suicide, it will be something which is very proximate to the time of the incident. And this is the only incident occasioning. There is no assault before this. How do we conclude that this is the man?
Ask my lord, in this. Only one matter when the priest.
Okay, I got it. So you come to the PW1 for a second.
W1, it shows that the Bisar was after the birth of the child. Returning from Dibrugarh, a meeting was held. And prior to that, children has already been delivered as per PW1.
So, Mr. Rua, how do you reconcile this? But the doctor's evidence is 16 months of pregnancy.
Yes, mothers is different, but fathers, as per father,
16 weeks. So this is something while crossing, it was done.
Ajahar is 1-9. She was examined on 6-9.
6-9.
According to them,
So 6-9, 16 weeks would be 2 months.
2 months.
16 weeks, 4 months.
As per Ajahar, 2 months.
2 months.
And only 5 days difference between medical examination.
Mr. Borua, you examined this. And see, there is only one incident. And see, come to the victim's statement, PW 19.
Interpreted by the
Be that as it may. Last line. I thereafter, due to the said incident, attempted to commit suicide by hanging. But my mother rescued me and slapped me, and I narrated my mother, so and so, so and so. My weather slapped. Thereafter, my father lost Ezahar, also a meeting. So this is in a sequence. But how do we determine that exactly on which date or proximate to which date this incident occasioned? Because if she commits suicide, the suicide cannot be committed after 1 month. And Mr. Another question, another query. Sign language is a language which has to be studied. Where is the evidence that the girl had studied sign language? The interpreters' things are little bit
Yes.
not very. I got it. I'm not going into that. I'm not going into that because the interpreter's evidence is there. But what about the proximity of the occasioning of the incident?
Interpreter is not
Any material on the date when the child was born? It was all there 1 year before.
When?
That is it. They deposed on One 2018. So the deposition is on 23/9/2019. Finding it very difficult.
According to PW8, then occurred in the month of August, September 2018. When the parent of the victim girl called a village meeting, then only I came to know about the incident.
But the affidavit, where do I get that statement?
PW8 and another PW had also stated that it is in the month September. That is, they have heard.
Where? This is some.
Wait.
So August, September.
PW4 also. 4 and 8, not by mother and father, but PW4 and 8.
Okay. Where do I get that?
PW4 page 15.
No, that August, September.
The second line, the incident occurring in the month of September 2018.
Okay, now let us find out. Let us say it is September. Where is the FIR?
FIR is 1. FIR was lodged on 1/9. First day of September. At that time, she was 2 months pregnant as per the father's.
And she was.
And if medically, it is 4 months.
Wait, 6/9/2018 is the medical examination. 16 weeks pregnancy. If we go back, if the incident is of August, September 2018, how can that's evidence coming on record? I can't ignore that. If that be so, September, then it is impossible that she was 16 weeks pregnant on 6/9.
Azhar was lost.
That is the father's view. Why should we, when there is evidence, your evidence that it is September, how can I go beyond that? At the same time, if this old man is there for no fault of his,
My lord.
we can't be swayed by emotions. We'll have to have some material. I'm not passing any order today. You go through it once nicely. Because these are the doubts which have come. So kindly try to clarify that. On the prayer of Mr. R.J. Borua, Learned Counsel, for the Learned Additional Public Prosecutor, registry to list this matter again on 19. 19/11/2025. Okay. Madam, you also go through this. And don't go through it like a partisan advocate. Go it as an amicus curiae. Because this is some genuine doubt I have now. Or are you also? Yes. How long will you take, Mr.
I'll try to be as brief as
Because
I understand, my lord.
we're having a time constraint.
Yes, my lord. Because
What are your grounds? One,
perversity. Then, my lord, the IO went beyond charges. Then, my lord, one relay board letter was relied on. That letter was never part of the charge.
huh.
Then, my lord, no reason was assigned in doing suo motu revision.
That is subsequent.
Yes. One factual aspect is that there was a delivery challan. All the witnesses said that while loading the next set of materials, a delivery challan was issued. But that delivery challan was never produced during the course of the inquiry.
Now,
First,
first question. You are a CRPF person. RPF personnel. You cannot be at any place according to your wish.
I was detailed.
You were detailed. So, if you were detailed, some responsibility also comes to you. So, what was your duty while detailing?
I was to witness that milord loading. But basically what happened on the key dates were fixed for of the scrap material. The power of attorney holder who got the milord work to load, he was having a power of attorney holder who used to come. The first date loading was done. Second date, 30% loading left. Actually, another RPF person, he was overseeing that work. I was not there. First loading was not overseen by me. Now, when he was on leave, I was detailed by the office that you witnessed that loading and unloading, my lord. So I went there as per the time schedule, and the power of it, when the loading was to happen, the power of attorney holder said that I cannot load the material because EOT crane was not there. One crane, that was supposed to come, that crane did not come. Now, when the loading did not happen, so officers, my senior officers, one is Kirasri Paul and one is Kollol Roy, they prepared one cancellation memorandum. It's like a piece of paper wherein a format is there. Reasons for cancellation they wrote that the power of attorney holder did not come for loading. But actual reason is that he came, but loading could not happen because of the non-availability of the EOT crane. So after signing that document, I went to my base, my office, at Hojai.
You also signed on that document?
Yes, I signed it. They prepared it because I have to sign, So I came back. Thereafter, the Chirasri Paul, who was the main custody, he did, since the truck was already there for loading, what she thought, this is my submission as per the statements, what she thought, the truck is idle. So another, portion of joist that the railway track was lying. So she wanted that instead of the truck going empty, I'll put this joist in the truck. She had a talk with the power of attorney holder also, and she sent those materials for weighment to Mandardoa weighing point, my lord.
After loading?
After loading. And all the witnesses during the course of the inquiry said that I was not there because I already left. After my leaving the place.
Did she come and say these things before the inquiry?
All the witnesses, not only she, other witnesses, even the driver also, he said.
But one driver?
One driver contradictory statement that I'll show, my lord. So after that, my lord, the truck was sent for loading. My lord, police personnel get hold of the truck. and thought that these are railway scrap. The truck driver was trying to sell it. So they arrested the truck driver, and accordingly a proceeding was initiated. Milord, against me, I was arrested, and thereafter everything, Milord. So basically, these are the facts, Milord.
Okay, let us come to the show cause.
Yes, Milord. Charge sheet, my lord, will
Memorandum.
find 3 specific charges. Page 52, it starts.
Page 54.
Page 54 is the relevant portion. On 23/4/2022, Sri so-and-so SIRPA post was detailed to witness auction delivery of part material of EOT crane against the bid sheet number so-and-so dated 7/3/2022 SRO number so-and-so from the lot number so-and-so. But Sri so-and-so SIRPA post AGY along with other witnessing authorities decided to cancel the delivery program and instead facilitated, my lordship will kindly mark this, facilitated in loading other railway materials into the truck number so-and-so, which was brought by the purchaser. SIC so-and-so also failed to ensure the delivery of assigned lot and facilitated lifting of other railway material which was not offered for delivery. So here, my lord, specific two allegations are there in Article 1 charge: facilitate to ensure delivery of assigned lot, fail to, and facilitated lifting of other materials. Now, charge number 2, as per auction delivery program, say so-and-so, the purchaser was present at the site on 23/4/2022 to effect the part delivery of EOT crane against bid sheet for so-and-so. However, in spite of the presence of all concerned officials, the representative of the purchaser at the site, SI Sri Prabhakar Das, with railway officials, falsely prepared a joint memorandum regarding cancellation of the auction delivery showing non-attendance of the purchaser. Whereas the representative of the purchaser was present, was involved in theft of railway material which was not offered for delivery. So here allegation is that falsely prepared joint memorandum showing the purchaser was not there and involved in theft.
Any proceeding against the lady SSC, DSF?
Yes,
Huh? What happened?
my lord, that proceeding was also imposed punishment.
What punishment? For what punishment?
A third number charge is that, my lord, there was a criminal case pending. That could not have been a charge at all, my lord.
Now, where is the statement of where is your written statement?
My written statement of defense, my lord, will find page 70, page 59.
These are the statements accompanying the show cause, page 63.
Page 63.
What is page 63?
Page 63 is the enquiry report. It
Okay.
starts from page 62.
Let us see Chirasri Paul's statement.
Yes, Chirasri Paul's statement, my lord, will find page 108.
Is there?
In the enquiry report also there, but the actual statement also I have annexed.
108.
108. I am to state that I am working in the capacity of so-and-so in the charge of so-and-so. I offered 3 EOT claims for auction against the bid sheet number so-and-so. Accordingly, delivery date was fixed on so-and-so. As per the program, the power of attorney holder attended the site on 5/4/2022 and delivered 30% of the total material. On 23/4/2022, as per the program, the power of attorney holder, Sri so-and-so, attended the site at about 12:30 hours with his labor and truck for taking delivery of the rest material. As we MLG Sri Kallol Mitra from accounts SI Sri so-and-so from security and myself present at the site to effect the delivery. On being attended the power of attorney holder, when I directed to load the auction material, he reported that the cutting of the rest of the material had not completed, for which it became difficult to load the material and requested to cancel the delivery. But I asked to effect the delivery of rest of the material on the date, as all the concerned official attended the site. Then the power of attorney holder Sri Minmay Majumdar expressed his inability to load the material due to heavy in nature and demanded to cancel the delivery on the date. Accordingly, I discussed the matter with SI Prabhakar Das and SV Kallol Mitra and agreed to cancel the delivery on the date. But my dealer has already left the site for taking lunch, for which SB Kallol Mitra himself started to prepare the cancelled memorandum. Accordingly, the joint memorandum was prepared by showing that the purchaser was not attended. Though I and Sri Prabhakar Das pointed out that cause of cancellation of delivery, but SV Kollol Mitra stated that being an accounts official, he better know to give reasons of cancellation. Anyway, I and Sri Prabhakar Das signed over the cancel memorandum at about hours. After cancellation, the delivery, I along with SI Prabhakar Das came to my office chamber, but SB so remained at the site. And I also made a survey of over the campus. After 10-15 minutes, though I called Kollol Mitra to my chamber, but he replied us wait for some time. Then SI Prabhakar Das told me that as the delivery has been cancelled, he wanted to return back to the post. Accordingly, he left my chamber. After few minutes, later, Kollol Mitra came to my chamber and told that some joists are lying inside the campus, which made a lot. He further stated that he has already discussed the matter with so-and-so SSC Diesel LMG regarding formation of a new lot of the joist. SV Kollol Mitra also told that Minmay Majumdar would provide the vehicle for weighment of the joist for preparing a new lot. He also advised me to request for the truck to carry the material up to Weybridge. Accordingly, on my request, Minmay Majumdar agreed to provide the truck to carry the joist and load it accordingly. I have issued a road challan against the loaded joist to carry up to Mandardesa, Weybridge and back to diesel set. There was a road challan. Subsequently, it came to my knowledge that the joist along with the truck was detained by RPF and seized accordingly. The driver and the handyman were also arrested by RPF. Subsequently, I was also arrested by RPF.
What is the penalty given to her?
I'll just check Milord once.
Just come back to the show cause notice. Raj,
Yes, ma'am.
so there are two parts in the first charge.
There are two parts in first charge.
With the other witnesses, authorities decided to cancel the delivery program. One, and instead facilitated loading of so-and-so, which was
Yes.
bought by the purchaser. Affect the delivery, so-and-so.
In fact, Chirasri Paul, in her cross, when I asked her whether I was there, she stated that I was not there. Not only all the that can
No, fine, we'll get it.
yes, madam. That can be gathered from the inquiry report itself.
Your responsibility would be
Yes.
to the extent of that description made in the cancellation memo.
They say that the reason for cancellation was POA holder did not
Not
come.
come.
Actually,
But she has clarified that.
exactly.
How did the inquiry officer take?
Yes, my lord. Inquiry officer kindly come. Crisis and page 69 is the discussion. Kindly come page 70. For evidence, exhibit 9, Lordship's got my. As per evidence, exhibit 9, it is feel that party charge was directed to witness auction delivery of three LOT so-and-so, fixed on so-and-so.
What is this EOT?
EOT is, my lord, electronic overhead traveling. Crane, my lord, it goes overhead, my lord. Exhibit evidences Exhibit 1, 2, 3, as well as deposition of PWs, it has transpired that Srimati Chirasri Paul so-and-so Kollol Mitra and representative of purchaser, power of attorney holder Sri Minma Mujumdar attended the delivery site on so-and-so. Deposition of PWs, it has been indicated that representative of the purchaser, that is the power of attorney holder Minma Mujumdar, reportedly requested to the railway official to cancel the delivery on date due to non-arrival of Hydra machine to load the heavy auction material. Accordingly, delivery was cancelled for the day due to so-and-so, so-and-so. And reveals that in spite of presence of representative of purchaser with the power of attorney, labor and truck delivery side, diesel sets lambding party charge have falsely implicated the fact and declared that purchaser was not available. As per available evidence, deposition of PWs, 40 pieces of railway joist were loaded from diesel set lambding in truck number so-and-so without any authority as per direction of SV, MLG Kollol Mitra and SSC Diesel MG Chirasri Paul. As per statement of the driver, this is important. As per statement of the driver, the loading of the material were started at 1300 hour and completed at 1600 hour. The deposition of all PWs as well as party charge, it is evidently established that party charge was available at the diesel set lambding up to 1530 hours while the loading of the truck was going on. These are the two lines that the inquiry officer gave extreme credence to come to a conclusion. The party charge was arrested on so-and-so in connection with so-and-so for alleged involvement in lifting of the railway materials without any authority. The party charge was forwarded before honorable court. Now, evidence also revealed that party charge failed to inform about cancellation of the auction delivery up to so-and-so either to SCR, LMG or any other higher official, though the delivery program was cancelled at much more earlier so-and-so. This was never a charge, my lord, that I failed to inform the higher authority. So that's how the IO went beyond charge. The party charge stated that he has passed the cancellation message to DCRG at 1730 hours, but the message was not delivered as he forgot to open the net connection, but no any credibility. In the defense statement, party charge stated that on so-and-so, other materials was loaded in the truck without his knowledge and without his permission, and claimed that he has left the site before loading the other materials in the truck, and pointed out that the deposition of PWs. The statement of SSC Diesel LMG Chirasri Paul has mentioned that as the delivery was cancelled, he wanted to return back to post. Accordingly, he left her chamber. Statement of Kollol Mitra SV stated that at the time of loading of the alleged material, he did not see the party charge near the truck. Statement of Mrinmoy Mujumdar stated that party charge was not present at the spot and not taken any permission from the party charge. Statement of Dilip Das also stated that he did not see the party charge at the site of loading of alleged material in the truck. He also stated that he did not take any permission from the party charge and he did not see the party charge anywhere in the diesel set at the time of departure of the truck from the diesel set. Considering the above facts and statements of PWDs, the party charge claimed that he was not involved in the case and not guilty against. So, Lordship can skip this, but on a careful examination of the above facts, evidence brought before the proceeding and deposition of the prosecution witnesses as well as deposition of the party, it is well established that he was attended the auction delivery at about so-and-so diesel set lambding, and other two railway officers so-and-so were also present. The representative of the purchaser, Sri so-and-so, was attended the delivery site at his labor and truck number so-and-so. The delivery was cancelled as per the request of the representative of the purchaser, Sri so-and-so. In this regard, Chirasri Paul deposed that the POA holder reported that the cutting of the rest of the material had not completed, for which it became difficult to load the material, and requested to cancel the delivery. But I asked the delivery of rest of the material on the date, as all the concerned official attended the site. Then the power of attorney holder Sri Minma Mujumdar expressed his inability to load the material due to the heavy nature and demanded to cancel the delivery on the date. Accordingly, I discussed the matter with SI Das and SB Kollo so-and-so. Besides, in the statement of the driver, my lord will kindly note this, of the truck number so-and-so, Sri Dilip Das has stated in his deposition that sometime later, one RPF officer along with madam came to the shed and observed my truck and left there. At about 1300 hours, Bijoy along with one short height man came and asked to park the truck nearby Joyce Tech. Accordingly, I took my truck to the place where they indicated. After that, about 40 pieces of joist loaded into my truck by some labor with the help of crane, which transpired that the party charge was has personally observed the truck so-and-so, which was brought by Mrinmoy Majumdar for loading of the auction sale. But at about 1300 hours, the same truck was utilized to load 40 pieces of joist from diesel set LMG. The deposition of the driver was further disclosed that truck loaded with 40 pieces of joist out from diesel set Lumding at 1600 hours of 23/4/2022. It is clear that the cancellation of the delivery was considered with due consent of all present railway officials and party charged with a mala fide intention. Besides the deposition of other witnesses as well as statement of the party charge have also transpired that the party charge was present at the diesel set Lumding up to 1530. The delivery was cancelled with due consent of the present railway officials and the party charge before 1300 hours of so-and-so. Thereby loaded 40 pieces of joist from diesel set Lumding in spite of having clear instruction of railway board model SOP dated so-and-so circulated senior DSC letter. The party charge neither ensured the actual lot or material as well as the departure of the truck from the site, nor informed the matter to the any higher authority about the cancellation of the delivery in time and remain silent till so-and-so. Had he been ensured that the departure of the truck instantly after being cancelled the delivery, it would have got the opportunity to load the material into the truck on that day. The party charge along with other railway officials have given instant opportunity to load the other material which was not offered for delivery. The truck was loaded with 40 pieces of joist while he was available in the diesel set, either of his ignorance or in his consent. But in both instances, the party charge showed his gross negligence to disobedience so-and-so, so-and-so. From the evidences, deposition of PW.
Where is that driver's evidence? It's here on
Yes,
record.
it's here, my lord. I also stated, I'll refer to the original statement, my lord. Actually, the driver gave a timing. That timing the enquiry officer took. My lord will kindly have
Just
page 110. The same driver, the next breath said that I was not there.
was that road challans established in the
Not exhibited during the court. All the witnesses said that there was a road challan, but that road challan was never produced during the course of the driver, only because of the fact that he in his statement he said 12.30 hours. The enquiry officer took a clue from there, and since I left diesel set on 15:45 hours,
this cancellation memo does not have a time.
Cancellation, Milord, they say at what time it was cancelled. I'll just give, Milord.
The lady's statement.
On 15.15, joint memo was prepared by Kollal Mitra and 15:15.
So 3:30. So he is there till 3.
No, he left on 15:45. The petitioner left on 15:45.
The loading, as per the driver, took place before that.
As per driver said 12:30, but at the same time, in page 64, if your lordship is referring to second paragraph, clarifying a question of the party charge, Sri Dilip Das driver stated that the party charge was not present at the site of loading the joist and also not given any direction instruction for loading any joist. Besides, the driver of the truck also stated that he did not see the party charge inside the diesel set while loaded truck was going out of the diesel set.
Where are you reading?
Page 64, enquiry officer's report.
Here also.
Yeah, yes, my lord, 110 also.
111.
No,
110.
110.
Yeah. Okay, so you are trying to project that this cross-examination part and the chief, if read together, this
Contradictory.
clarification that he was not there
Yes.
when it was loading, which was after 12:30 to some time, is apparent.
But all the witnesses, Chirasri Paul, Kollol Mitra, even the power of attorney holder, Minmay Mujumdar, he also told in his reply that I was not there. Nobody had seen me at the time of loading of the truck. But this driver, he gave some contradictory statement, because if he says that 12:30 hours the loading was done, and he should have said that I was there. Because I was there.
Now,
to
if
feel-
there was a road challan, why was this vehicle detected?
That I don't know, Milord. Because in fact, from reading the records, my understanding is that since the truck, instead of going the truck empty, they tried to create another lot, and with a road challan, they sent it for women so that it can come back to the diesel set. All the witnesses said that the second time the vehicle was loaded so that the women can be done and it can be brought back, and another.
And is there
can be
any
created.
material that the power of attorney will be hold as the purchaser?
Yes, purchaser.
So he has purchased a certain lot of material. Whether the lot of material taken out finally was within the lot he had purchased or it was beyond the lot.
Subsequent, the empty truck, it was beyond the lot. Extra
The railway joysticks that was
joysticks
being
are railway
tracks that was being tried to be taken then.
That is, Milord, I am not sending Chirasri Paul or
Okay,
Kollal
get me
Mitra.
what happened to Chirasri Paul. When? Tomorrow? Chirasri
Penalty.
Paul. And you are terminated.
Compulsory retirement from service. I
Because
only
you are a
2 years.
police, you are a discipline force.
I understand discipline force, but the thing is, my lord, there has to be evidence.
And what about Kollal?
My instruction.
Next Tuesday.
Monday. Monday boot is in 19th. But Mr. H.K. Das, Learned Counsel for the petitioner. H.K. Das has made his submissions, however, the same remains in. So, Mr. S.S. Roy, Learned Counsel, registry to list this matter on 19 and 2025 for further hearing. Interesting.
I'll try to explain something more. Because
Can you get the records of Chirasri Paul?
much obliged, deeply obliged.
In this case, on behalf
On the prayer made on behalf of Mr. D. Mojumdar, Learned Edition General Assam, for an accommodation in the matter today on account of personal income. Registry to list those matters in on 25th, 27. Why, don't fix a create for adjournment. If you're not there, tell me, I'll give you a date. When do you want it? 18, 19, not possible. Because this have to be heard. There is a, let us put it on second, two. Yes.
Admitted thing, Lordship.
What happened to the appeal, madam?
Appeal is fixed on not the appeal.
You will be appearing on that day. In the, okay, we'll fix it on 2nd then. But 4th, okay. Heard the learned counsel for the parties. Ms. Bhattaji, learned counsel for the respondent, additional senior government advocate appearing for the respondent, submit that the writ appeal number, writ appeal preferred by the state against the order dated, against the judgment dated, judgment order passed in WPC number 1053/2024 has been directed to be listed, is being listed on 1/12/2024-25. So accordingly, the learned counsel for the petition appraise that the present writ petition be taken up again on 4/12/2025. Interim order, nothing, it's already continued.
The second inquiry that
That was stopped.
that is stayed by the ombudsman.
Your name? You're not there? You're appearing for?
NN Upadhyay.
A prayer is made on behalf Mr. No, your name? PP Kakoti, learned counsel for learned counsel appearing on behalf of Mr. NN Upadhyay, learned counsel for the petitioner, submits on instructions, on instructions, that the present writ petition has been rendered infructuous during its pendency before this court. Full stop. He prays that the present petition be closed. Full stop. In view of Mr. N. Upadhyay, learned counsel for the petitioner does not object to the said prayer made by the learned counsel for the. Full stop. In view of the above submission, in view of the submission made by the learned counsel for the petitioner, the present writ petition stands closed on being rendered infructuous. Full stop. Oh, full.
Published.
Heard the learned counsel for the parties. Hearing remains inconclusive. Registry to list this matter again on 2/12/2025. 2/12. You prepare. We'll be there.
So I got the reply also.
Yes, that's why I want. Give me a reply.
Okay.
Beating around the bush will not do. You will have to come direct attack. Yes.
You'll find at page 36.
30?
6. First advertisement, Lordship. This one was Lordship. By the subsequent 2009.
When was the selection?
Yes, Lordship. And you see, this one of all earlier notification issued by social Governor of Assam is pleased. Question so eligibility criteria. Roman 1.
Mr. Soikia, examine this, make your state permissions. Got it.
That is the
When you want it. Heard the parties. Heard the learned counsel for the parties. However, push up. Hearing remains inconclusive. Learned as prayed for by the learned counsel for the parties. Registry to list this matter again on 4/12/2025. For further hearing. You're not in talking terms with Mr. Soikia.
I am
And then ask him, he'll give you. For further